Good afternoon, ladies and gentlemen, and welcome to Oldham County Fiscal Court. I'm David Vogel, Judge Executive. We're happy to have all of you here today for our meeting. This is August 19th, 2025. If you're able, please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. If you have a cell phone with you today, I'd ask you to please turn it to off or vibrate. We've some anticipation of a police alert that will be put out sometime during the next hour. That may cause everyone's phone to go off. I think we have a senior citizen that's lost, and they're going to do a golden alert at some point if the person is not found. So rather than have all of our cell phones go off at the same time, I guess we get a good laugh out of it, but that's what it's about. So if you turn it to off or vibrate, it won't interrupt the meeting. We're at that point. So now I'm going to ask our clerk, Holly Prain, to please call the roll.
Magistrate Likens.
Here.
Magistrate Tice.
Here.
Magistrate Woosley.
Here.
Magistrate Jeffries.
Here.
Magistrate Hounds.
Here.
Magistrate Hawkins. Here. Magistrate Logsdon.
Present.
Judge Vogel.
Here. Having 8 of the 9 members of the fiscal court present, this meeting is now in session. Is there a motion to accept the agenda?
So moved.
Yes, sir.
A couple questions that I'd like to change.
All right.
Okay?
Sure.
On, let's see, make sure I get it right. Under contracts, resolutions, E. My mic's not on, sorry. Under E, contracts, resolutions, proposed resolutions to suspend county maintenance of roads in the county maintenance system within the Oregon Creek Farm subdivision, whereas tabled from 6/29/25. I'd like to remove tabled from 6/29/25.
All right. After 30 days, it can't come back up from the table, so it's essentially a new motion. All right, go ahead with the second request you have.
Yes, under F, opioid litigation update, I would like to move that closed session down after H, after board appointments, so we would have the 2 closed sessions and we could complete our business other than those 2 sessions. I'd like to move F down after H.
All right.
And I'll move both of those changes.
All right, I think item F under contracts and resolutions it's going to be connected to that closed session. We may not need a closed session, but if we do, we'll have it. All right.
Okay.
All right, any other changes? Magistrate Tice.
I didn't understand what Magistrate Jeffries said on number E on the contracts. Are we postponing that until another date?
No, the only thing we're
moving
doing
it
is
from-
taking off the language tabled from 6/29/25. As Judge Vogel has pointed out, after 30 days, it'll just be, it will stand on its own. That proposed resolution to suspend, we will move forward with that today.
Still going forward?
Correct.
Thank you, I misunderstood. Thank you.
Anything else? All right, all in favor, please say aye.
Aye.
Anyone opposed? Motion carries. Thank you. We'll go up and have approval now of our minutes from the meeting on August 5th.
So moved.
Second.
Are there any corrections?
Just a question, Judge.
Yes, sir.
It says July 15th minutes were previously approved, but I somehow left out approving the payables, so we need a motion to approve the amended 7:15 minutes.
Yeah, we'll have 2 sets we need to approve.
All right.
Yes.
Okay, are we going to approve those minutes as well here? Can we do it separately or do it in one?
Yeah, separately.
Is that all right? We'll do the minutes from August 5th first. Is there a motion to approve those?
So moved.
Second.
We did? Okay. I'm confused about what we're doing right there now.
We have a motion on the floor to approve the minutes from 8/5/25. It's been
Right.
seconded.
Right.
And then we'll need to make a second motion to approve the 7:15 payables.
Oh, okay. All right. So is there a motion to approve the minutes from August 5th?
We already have a motion and seconded.
And a
Just need
All right,
vote.
all in favor, please say aye.
Aye.
All right. Now we'll go on and approve the minutes,
Payables.
payables, that is, from 7:15, is that correct? Amended?
I'll second.
Can I just clarify?
Yes?
Sorry. You all did approve the payables. I forgot to add it into the minutes. So the minutes are just amended minutes stating that you all approved the minutes. Or I'm sorry, that you approved the payables. So I just need a motion to approve the 7:15 new minutes that specifically state that you all approved the payables.
Motion made.
Second.
All right.
Second.
All in favor, please say aye.
Aye.
All right, motion carries. Now we're at public comment, the time during our meeting when any Oldham County resident would like to address the fiscal court, you're able to do so, and we generally allow up to 4 minutes. We ask you to please state your name and address.
Morning, Judge, members of the court. I'm Jerry Nart, representing the Board of Directors for the Veterans Memorial Park of Kentucky, located on the grounds of the South Oldham High School and Middle School. I'm just here to do my first reminder that we'll be holding an event there on Saturday, September the 6th at 11 a.m. It's our annual event, and it's also combined with the observance of 9/11, our Oldham County 9/11 observance. Our guest speaker this time is, if you will, a member of the county. He's a veteran and been a member of the county and very involved in different things. And it's Lieutenant Colonel Stephen Davis, PhD type, retired from the Army National Guard. He's also a member of the Board of Directors and the current commander of the American Legion Post here in Oldham County. Very quick and to the point.
All right?
I have a question.
Yes.
Could you explain to the public how you go about buying the bricks over there? Because my father was World War II, and I bought him a brick. And also, I went over there to look for it, and I couldn't hardly find the place, and I didn't know if you could try to get some sort of sign. I don't know if there is one now, but maybe a bronze plaque that says where it is so you can see it from the highway.
So multiple questions there.
Okay.
So the first one, how to acquire a brick. And what Magistrate Likens is referring to is that at the park, right at the entrance, there is a brick pad, if you will, for pavers. And anyone that's a veteran may be memorialized, if you will, or you may purchase that brick it's a fundraiser for us, to put information about your veteran that you would like to do. We have revamped the website, the Facebook page, so you can Google, if you will, Veterans Memorial Park of Kentucky, and take a link to there. I happen to have employment down in the lobby a couple days a week, and I put some of the order forms actually up on the bulletin board there, but I can always be contacted for more. I will point out, though, that the bricks or the pavers are only $50 right now. And when you look at that type of thing throughout the country through other things, it's a heck of a deal. But we will be going up to $75 the 1st of September, which is still a pretty good deal. I got one for my dad at the National Army Museum, and they wanted $250 for it. So it's still a pretty good deal. When we fill that brick pad up, we're going to put another one in. But on the website, if you will, for me or down in the lobby, whatever you might need to get you hooked up with a brick. The second one, as far as a sign for the park, we do have signage there where it's not lighted at night, which is an issue we're dealing with, and we'd like to put up a better one, if you will. There is a sign down close to the roadway, Veterans Memorial Park. It's a wooden sign. It's colorful. You can see it. What we do have a problem with, though, is the high school puts other signage up that kind of blocks that one sometime. And then if you get up on top of the hill, there's a small granite one up there right by the driveway in front of the school. But the park is all by donations, grants, funding. Nobody takes any salary or stipend, if you will. So we have to put in what we can do with the donations that we get. This year we'll be commemorating a new monument that on one side commemorates those who have received the Purple Heart Medal, having suffered combat wounds. On the other side, it pays tribute to those POWs and MIAs. That's the monument going in today. There are a couple other informational pedestals that were put in. That's the pedestal where students from the county have helped craft that verbiage about that conflict, and because we're all about the students, so we have them involved. But we're working on a better sign, sir. Thank you.
All right, thank you, Jerry. I think
to
we
see
have
you.
a couple of events there every year
Yes.
that I always attend, and the Veterans Memorial Park has gone from an idea in Don Helton's mind to it's well on its way to being a colossus. It's
We have-
if you
we have-
haven't been there, it's extremely well worth the visit in our county.
We have over 8 monuments in there now. The average cost of those are anywhere from $34,000 to $40,000. And again, it's all by donations. The American Legion hosts their Memorial Day event there. We have flag retirements on Flag Day there every year, June 14th or thereabouts. And so we do quite a bit.
Right.
I'll be back to see you on the meeting again right before the event, but I just wanted to go ahead and plant the seed now.
Right. Thank you, Jerry.
Okay, thank you.
I agree with Magistrate Likens. There is marking there, but the last time I looked, the South Oldham championship running team or something had a sign right in front of it. So we need to coordinate with them, I think, to put that somewhere else. But it could use a lot bigger sign because it's certainly very well worth it. Okay, is there anybody else who would like to speak to the fiscal court now?
Judge, the
sir.
record should reflect that Magistrate Dye is joining our meeting.
Yeah, we want to make a notation. Magistrate Dye arrived at the meeting at 2:10. All right, thank you.
Good afternoon, everyone. My name is Andrew. I live at 2320 Ridge Road in Oregon Creek Farms subdivision. I would like to discuss the resolution by Magistrate Jeffries to discontinue support of the maintenance for the road there in that subdivision. It has been asserted that the roads in that area are private roads, and I don't like that term, because technically a private road can only be owned by one person and for a direction to a specific residence. In this case, the road itself contains 5 different offshoots, and right now there are 38 different residences on those roads. So that kind of overplays the role of a private road. And according to KRS 178-405, when a private road, street, or highway in an unincorporated area, which the subdivision technically is, in any county has been used by the general public openly, continuously, and notoriously for a period of at least 15 years, it shall be implied that such road, street, or highway may be dedicated to public use. Therefore, it is a public road. So how can it be classified as a private road? Not in my book, it can't. And because of it being a public road, under also KRS 178.410, the court has the determination that it can accept the road for appropriate, it shall notify, okay, let me see now. Upon application by a specific person or corporation, public or private, the fiscal court shall determine whether the conditions of the road of KRS 178.405 have been satisfied. I think that was done in 2004 by the resolution that was passed by the fiscal court at that time, where it accepted responsibility for maintenance for that road, where it says, whereas Oldham County wishes to maintain the roads in Oregon Creek Farms subdivision on behalf of landowners who will retain ownership of said roads. Now, if the county's going to maintain maintenance on those roads, how can we be owners of it? I don't see how that can work. So I would really appreciate if the magistrates and the judge executive would vote negatively on this resolution and continued maintenance as it is. Thank you very much for your time.
Thank you. Anyone else would like to speak? All right.
Hello, everybody hear me okay? Tom Cray, I live at 2225 Ridge Road. I'm one of the people, as seen in the 50 state constitutions. And we, including those living in Oldham Creek Farms, have secured constitutional rights that ensure our government agencies that we fund are instituted for our peace, safety, happiness, and protection of our property. Discontinuance of maintenance of these roads within Oldham Creek Farms will endanger the safety and health of everyone that lives up there. We call it home. I provided each of you with a notice in regards to the proposed resolution. Did everybody have a chance to review that?
Yes.
Yes, everybody did? Okay. Well, we have expectations regarding public services that we fund. Most importantly, we expect emergency responders to have access to our homes that the county approved to be built in the first place. We also expect access for safe travel in our daily lives, mail delivery, school transportation, waste management, and public utilities. I wanted to address the 4 items that the resolution uses to discontinue, that justifies discontinuance of the road. Number 1, expense to maintain roads in Oldham Creek Farm subdivision has greatly exceeded the amount contained in the original resolution. The county is prohibited by Kentucky Constitution and statute from using tax money levied for one purpose for another purpose. And my open records request filed in June exposed grossly inadequate record keeping by the county of those funds, whether it was money coming in or money issued out for that project. I only received the estimate from 24-25 that's in that packet that I sent you. This fact was also known by county officials. We are not the ones with the fiscal dilemma. Number 2, the roads as originally constructed did not comply with county standards. In May 23rd, 1972, Oldham County Planning and Zoning Commission had a meeting. They approved at 7-3 that the roads be constructed below the standards published at that time. The reason that they gave was for economic growth. Well, 50 years later, it's now become a public safety and a health issue. So economic growth, it can't be the primary issue there. We depend on those roads just to conduct life and receive county services. Number 3, KRS prevents fiscal court from accepting a private road. The roads do not meet statutory or county definitions of private road. They are not private roads, they are public roads. There is no mention of private on the plats or the deed restrictions. The roads don't even meet your own definitions. And number 4, the item, county has never accepted said roads into the county maintenance system as landowners retain ownership. The county approved the construction of said roads below the published standards at that time. We don't have any ownership of said roads. No records of inspections during maintenance agreement per resolution. I requested that through open records request. And there is no records of inspections or county approval during original construction. And I wanted to read KRS under Title IX, Planning and Zoning, 100.277, commission approval required for subdivisions. Paragraph 1, all subdivision of land shall receive commission approval. We received that. And paragraph 4, any street or public ground which has been dedicated shall be accepted for maintenance by the legislative body after it has received final plat approval by the Planning Commission. We meet both of those requirements.
All right, thank you, Mr. Gray. Is
Thank you.
there anyone else would like to address that?
My name is Alec Gross. I live at 6901 Hillvale Drive in Oldham Creek Farm subdivision. And I was nominated to be the road commissioner about 20 years ago, maybe a little longer. But at any rate, when the resolution was passed in 2004 that the county would maintain the roads using the money that we collect to do that, which, just like Tom said, there's no record of the money that they show coming in or the money that they, that they say that they have spent on our roads. However, when the roads are in bad enough shape up there, the mail delivery stops, buses will quit running. And fortunately, we haven't had to deal with that for the last few years. One of the things that I've always contended is that when these roads were put in back in 1972, they were put in based on the current county standards at that time. And the reaction that I always get is, well, there weren't any county standards at that time. Tom just proved that wrong because there were. So we have asked the county to absorb these roads into the county road department several times over the last several years, and to no avail. It still hasn't gotten done. So I'm going to ask fiscal court today if you will accept the roads in Oregon Creek Farms into the county system and maintain them as such. Thank you.
I don't want to get in the middle of, did the last gentleman say that they were accepted by the planning commission below standard? And you're saying there were no standards. So what is it?
What I was told was they
Right.
have never been accepted.
All right, anybody else like to speak to this?
Good afternoon. My name is Daniel Swizer. I live at 2324 Ridge Road. I am here just to briefly articulate the negative impacts this proposed resolution on suspension of the road county maintenance on Oregon Creek Farms is. And just kind of, I want to give you a background. I moved out of Jefferson County about 6 years ago. Me and my brother started a farm out there. We've been reshaping the land, kind of building, and clearing land and kind of starting our own chicken farm and whatnot. And now I kind of moved out there because the quaintness of the gravel road. And it said, when I bought the house and everything, that this was included. Oldham County was in charge of maintaining the roads. Thought, no problem. I'm getting taxed on it. It was no big deal. But this decision, being proposed by this court right now is called into my question, why did I move to Oldham County? I fled Jefferson County for many reasons. But right now, I'm just kind of worried about this hasty decision, how big of an unnecessary burden it is to me and all my neighbors. There are many financial implications that this will do. Homeowners insurance, I don't understand how anybody could be insured with their house out there if you don't have, a road that's up to quality standards that a fire truck can get up there. A lot of my neighbors have mortgages. Luckily, I do not. But how are they going to, resell their house? How's their house going to depreciate and everything like that? Also, Tom brought up the EMS service and fire, police. We have school buses that go on there. To be a private road, I understand that school buses would not be traveling on a private road, especially going how fast they are down our road. And it's just, this really calls into question whether or not I want to build a new house on my place. I want to. I've actually, submitted the forms and everything like that. But I'm kind of held up right now based on this decision upcoming. And I just wanted to kind of briefly articulate, all that for you. Thank you.
Thank you.
Thank you. My name is Linda Way. I live at 2320 Ridge Road. I would like to bring up KRS 178116, discontinuance of a road. Any county road or road formerly maintained by the county or state shall be deemed discontinued, and possession shall revert to the owner or owners of the tract of land to which it originally belonged, unless at least one of these following conditions exists. A public need is served by the road.
Ma'am, I cannot hear you at all.
Okay.
Please try
The-
to project.
Okay. Any one of the following conditions exists. A public need is served by the road. The road provides a necessary access for a private person. The road has been maintained and policed by the county or state within a 3-year period. You all have maintained it for over 15 years. We also have a KRS that states that anything over 15 years becomes your responsibility. There are no ifs, ands, or buts. Our family's safety counts on you. Thank you.
Good afternoon, everyone. My name's Will Swizer. I live at 2324 Ridge Road. These are all my great neighbors here. Love you guys. Just basically, I got the main points that I wanted to reiterate from everyone. It's obviously a public road. Over 15 years, it becomes a public road. It's on you all now. It really is. It really is. What's going to happen when a fire truck or the police can't get up there and it's emergency? It's going to be your all's fault. You all are going to all be held responsible. You're all going to be held responsible, and I hope you all can deal with that, but I wouldn't be able to. Another main point is, where are all the records? I'm asking again, where are all the records from the taxes collected from the road? Where'd they go? We have 1 year from 2024. What's going on there? Anybody have any insight? I didn't think so. I pay taxes in this county. I try to be a good neighbor to my neighbors, and you guys are really just... like everyone else said, you're causing a really bad hindrance in our life, and you all should vote no today. And that's really all I got to say.
May I speak, sir?
Pardon?
May I speak?
Yes, your name and address, please.
My name is Charles Klipner. I live at 7007 Oregon Creek Circle. All right, so I moved from Oldham County. I went to high school out here, and I moved to Jefferson County. And when my children became the age of high school students, I moved back out here because I remembered how great it was out here to ride dirt bikes, chop wood, shoot guns, all the good stuff. I left Louisville after I've got 3 generations of Clintoners in Louisville, Kentucky, Louisville Scrapyard, Louisville Construction. There's now Klempner Brothers Scrapyard. I'm very upset. I don't do public speaking. I wasn't planning on speaking, but my family had done business in Louisville for 3 generations. There's actually Klempners out in Henry County, Klempner Excavations that did your courthouse. Today, I'm trying to start my own construction company out here, and it's working good, but I'm not good with the books. My brother did that, and he's not with us. So I moved out to Oldham County, and I forgot, I also lost a property from the Louisville Land Bank. They were supposed to send a warning officer. They did not. I'm done with Jefferson County. After all that trash out there, I'm done. I came out to this county hoping that you guys were different. I'm feeling the same. I mean, with everything that's going on, even with the, the electrical data center, and the undercover conversations that you guys have had. I mean, I feel like moving. I mean, selling my house, moving. Y'all have it. You want to be Jefferson County? You're right on your way.
Hello, I'm Kathy Sassy. I'm the big mouth on the corner. And yes, I've called the road department many times. Most of the time, it's because the road is impassable and we are driving through our neighbors' yards to get out, just to go to work, go to the grocery. We've had times where an ambulance has had to come to a crawl on an emergency because the road was so impassable. That neighbor died. So now you know why. There's another reason why we're so upset that this road has been neglected for so long. We are fortunate that one of our neighbors has not charged us for the last we're in August, so 8 months. He has been maintaining the road, and it's the best it's ever been, but he's doing it for nothing. We can't expect him to continue to do that until the sun burns out. So I really hope you all take a strong look at just exactly what's going on and how lives are being affected. Because I've lost a very close friend and neighbor because the ambulance took so long to get there. And that's no fault of the crew.
Anybody else who would like to address the fiscal court?
My name is Christy Lefevre.
Well, I have to speak
My name
louder.
is Christy Lefevre. I live at 2232 Ridge Road. All of these neighbors have made valid points. There's one thing that I noticed that they didn't mention, and this is a commission approval required for subdivisions. This is statute 100.277. It has 5 sections. They all talk about accepting the road as it will be received by the commission. If you look at section 4, it reads, any street or other public ground which has been dedicated shall be accepted for maintenance by the legislative body after it has received final plat approval by the Planning Commission. Any street that has been built in accordance with specific standards set forth in the subdivision regulations, which they've stated it was, by ordinance shall be, by operation of law, automatically accepted for maintenance by a legislative body 45 days after final approval. Well, that was in 1972 or 70. I mean, that's 51 years ago. What changed that we were called into a neighborhood meeting on the weekend of July 4th? I was told on that Sunday that you guys are going to meet on Tuesday, and we can take a lien on our house. We could set up a separate tax setting to save the money to take care of the road. Or we could set up an HOA, and then people would have to go and door to door, I guess, and collect money to take care of our road. What changed? And why would that meeting be called over July 4th weekend when really nobody can even attend? But that's the first time we heard of it. I'm grateful you guys did set this off to give us enough time to sort this out. But I don't understand how we pay extra on our taxes. I mean, it's a separate part of my property taxes every year that I pay. And there's no documentation to show where that money's went. We're just told it's just too expensive now, but you don't tell us what you did with the money. In reference to something that was mentioned about the previous issues in this court, it was said during one of those meetings that Oldham County has a surplus, a very large one. And they claimed $11 million surplus there. Well, I was told it cost $2.2 million to fix this road. That would mean you have an $8.8 million surplus, and there's an accounting error there, but the money exists to fix the road or to maintain the road. So I cannot understand how you could vote against 40 or so households that we all live there. If I try to sell this home and there's no maintenance on the roads, what's that going to do? Who's going to buy that? Who's going to take it? What mortgage is going to be allowed if you can't have homeowners insurance? There's a lot of ramifications to this decision that affect 40-some families. And I will mention that I found out at a previous meeting that our ruling was tabled, but then the next item of business was to fix a Buckner golf course parking lot. How is that even more important than someone's home, their roads that go to their house? That is upsetting. And I hope that y'all kind of take this into consideration and decide that the county does have an obligation to take care of roads in the county that they've taken care of for 51 years. I just would appreciate that. Thank you.
All right, anyone else?
Good afternoon. My name's Albert Harrison. I live at 114 McMakin Manor. My name is connected to this project, but it's not me, it's my father's name. He was an Albert Harrison, I'm a John Albert Harrison. That is one of either 71 or 72 subdivisions in Oldham County with a Harrison name on it.
Albert, will you pull your mic up? I'm having a hard time hearing you over here.
Yeah, there you go.
And four.
Speak into it. We're having a hard time hearing you over here.
It's on.
Yeah.
I'll talk without it. But things have been said and inferred that something was done improperly when the roads were being built. There's not a person alive who knows anything about how those roads were built. Nobody. And this is not the first time I've heard this group criticize work that my father did. You have no idea what his background is. Nobody does. You talk about how rough Oregon Creek is. Before we moved to Kentucky, he was in charge of the crew that paved the streets of Juneau, Alaska. They got hills. They call them mountains. These grades out here at Oregon Creek are nothing. Does he know anything about construction? When they finished that project the next year, they started building what became the International Airport at Anchorage, Alaska. And his signature's on that project. Then we moved here, and he went with the Corps of Engineers. Every feature on the Ohio River from Paducah to Pennsylvania has got his signature on it. He headed the group that determined the location and the type of foundations that were needed to put these things on the river. Then he got into doing the lakes. He redesigned Crystal Lake, he redesigned Harmony Lake, and his signature is on every state dam in Kentucky. So please I beg you, quit criticizing somebody who's not here to defend himself, and let's quit trying to find out who's at fault. I think almost everybody connected to this has done something improper. In 1976, I designed and laid out Goshen Hills subdivision. At that time, we did not have a county engineer. Jim Lentz, remember him from Westport? He was the head of the road department, and he was charged with inspecting new construction. And if I remember correctly, he drove a little orange pickup. Been nice to see him. But nobody said anything about inspections of any of the roads in Oregon Creek Farms. Jim Silliman's got a complete set of road construction plans. Somebody has said there were no plans. Well, I think Mr. Silliman might disagree with that. There were plans. Best set of plans I think my father turned out. But you've got lots out there that have on paper a 60-foot right-of-way containing what's supposed to be a street. It's not there. Never got built. You got people who own the lots on both sides of a street that does not exist. And they're paying this annual fee for what? They don't use the road. They probably don't even know where their lots are. And that's in two areas. One of them's got 5 lots, no access. Another one's got 2 lots, no access. But the people who don't live there, who don't have a house there, they're getting stuck with the road tax, even though they're never there. PVA office has put together lots that have common ownership, but they're described as separate tracts in the deed. Putting them together in the PVA office does not make it one tract. It has to be approved by the Planning Commission. The Planning Commission has issued building permits. They've required access permits for new construction. Everybody out there has been treated as if they lived in a fully approved subdivision until now. So I don't know that anybody in here has got clean hands on this one.
Mr. Harrison, do you need more time? You're out of time. Do you need more time?
Yeah, 2 minutes maybe.
Make a motion. We give him 2 more minutes.
Second.
All in favor, please say aye.
Aye.
I don't think you got it. Time's up, Albert.
I'm sorry, I didn't hear what they
We
said.
just took a vote. You didn't get enough. You didn't get the majority of the court to continue. So,
With all due respect, I got what I expected. Thank you.
well, I would like to, Albert, before you get away here, I personally have not heard anyone criticize your father. I've never heard his name come up before today in any of this, but maybe someone has, but I haven't heard anybody say anything critical about your father, so I don't know. Okay. And the other thing that you mentioned that maybe I'll be proven wrong here, but you said there's roads on the plat, but the county doesn't build roads. The subdivision developer builds roads, and they are accepted into the county when they meet county standards. The fact that people have roads on their property shown on a plat is not the fault of the county government, because we don't build roads. You know that. So why those roads were not built is not the fault of the county government. Now, I'm not defending it. You know, we're a long time. We're, a long way into Oregon Creek, and, I'm very sympathetic with what's happening here today. I think we all are, and I think we need to discuss this further as a group where we stand. But
We would love to be involved in that.
Pardon? Pardon me?
I and the residents would like to be involved in some type of committee, task force, whatever you want to call it.
Yeah, well, that's up to the court if we're going to go past today or not. I don't know. But I'm just saying that what is being said is we're not hard-hearted. You know that. And but there are laws, and so I don't know. Where the road committee and the county engineer have developed a point of view on this. It's been brought before the court, and I guess it'll have to be discussed. And anyway.
Well, perhaps I'm not correct either, but I think I am. You cannot record a subdivision plat without the approval of the planning commission.
No, and the planning commission doesn't approve it. It's for today, the fiscal court accepts roads into the county. The planning commission does not. Now, maybe that was the way it was 50 years ago, but certainly not the way today.
Well, all of that was done properly. There are 2 sheets for each of the 3 sections. And each one of those sheets bears the signature of the planning commission administrator, who at that time was Raymond Moore. And he had his own stamp. So every one of the sheets for the record plat's got 2 stamps on it with his signature twice. The planning commission did approve it, and they assigned the task to Mr. Moore to go to fiscal court to get everything finalized. That did not happen, but we don't know why.
So the fiscal court never did approve the
We
plan.
cannot find it in the minutes.
Right. It can't be found. I think that's one of the issues. But, we'll see. Let's let the road committee take it forward
Well,
and see.
it's not their fault.
Right. I understand. Certainly do. Thank you. But I don't want anybody to think that anybody's criticizing your dad, because I don't think that was in the intention anywhere. Okay, you've already spoken, but I'll let you come forward again for just a minute. But okay.
I just wanted to bring up 2 things. One of the things that Tom was talking about was the safety of fire, rescue, EMT, being able to get up there. Back in the winter, this past year, we couldn't get up the hill. And county road department came up there. They couldn't get up the hill, so I mean it was impassable. Someone came from the top of the hill down, slid all the way down, and went over into the creek. So if the county can't get up there. The other thing is, how many people that are here representing Oregon Creek that has built a new house in the last 20 years? Did y'all have to pay a road encroachment fee? That's another thing is I know that several of us have paid a road encroachment fee. So if it was a private road, why would we pay a road encroachment fee? Just food for thought.
All right. Is there anyone else who wants to address this or any other topic? All right. Manager Jeffries, would court members, would anybody have any issue bringing this forward right now? And let's take it.
On the agenda as far as?
Yes, right.
I'm
I
okay
think
with bringing it forward.
These people are here. They made their points, and I think
Mr. Baxter, is that okay to move it up on the agenda?
Just as a point of order, I think you'd need to amend the agenda, but I think.
Is your mic on?
It is. Just as a point of order, I think you would need to amend the agenda, Your Honor, to advance this from under contracts, E, so somebody needs to make a motion so you all can continue this discussion.
Judge, I'll move that we amend the agenda to move that up to discuss it at this point right after public comment. I think the road committee we'll make our recommendation. Jim Sellerman, our county engineer, can come forward and bring his information, and then our county attorney, Barry Baxter, I think has some information that he needs to bring forward. So I would move that we amend the agenda to move it up to right under public comment and continue with the discussion on the proposed resolution to suspend county maintenance of roads not in the county maintenance system.
Second.
All right,
Discussion.
all right. Magistrate Hawkins?
Is this essentially saying that, I know Becky's here to discuss something under letter D. Mr. Rhodes is here from the Health Department to discuss something. Is this saying that they should be, that they should come after this and that this is more important? Is that the message? And then there's also another community business. We have a whole second reading. We have our staff here from Planning and Zoning to talk about a second reading for something on 53. So I just want to make sure that what the message is that we're sending, that one thing is more important than some of the other people that are here for different things.
Well,
I think
I
the
don't
judge
think
is
it's
saying, since
necessarily.
we're already talking about it, let's just
Pardon?
go ahead. I think you're saying, since we were talking about it, let's just go ahead and finish it.
That's what I'm trying to say, and the other, I'm sorry for the delay that's causing other people to come. All the other people came with no expectation of exactly when their item would be discussed on the agenda. We posted an agenda, but it was not, prior, so I'm sorry for a delay that's incurred by any other individuals, but I think, the right thing to do is to discuss this right now with these people who've come to discuss this and not try to separate the issue from the remarks that have been made. So we've got a motion on the floor to go ahead and move this up on the agenda. All in favor, please say aye.
Aye.
Anyone opposed?
Opposed to that.
All right, motion carries 8-1. Magistrate Jeffries.
Yes, Judge, thank you. And with that, I will just say that the road committee, I believe at our June meeting, voted as 2-1 to send this resolution to the fiscal court for consideration. And if it's okay, if it's proper with you, Judge, I will read. It's a fairly lengthy resolution that we are proposing, the road committee is proposing and recommended to fiscal court. Is that okay to read
Yes, sir.
that
Proceed.
into the record? All right, Judge, the resolution number is 01.
Hold on a second.
Oh,
If
sorry.
anybody here who wants to take a break while we go through this, we won't be offended. We know it's hard to sit through something that doesn't affect you, but particularly in the front row, these chairs are not wide. They're about an inch shorter than everything, less width than everything else. So go ahead.
Okay. With that, Judge, the resolution number is 01062625. And whereas pursuant to Resolution 01072004, adopted by the court on the 20th day of July 2004, Oldham County agreed to assist with the maintenance of certain subdivision roads, namely Ridge Road, Oregon Circle Road, Hillview Road, Ridgeway Road, and Ridgeway Circle in Oregon Creek Farm subdivision. And whereas the expense to maintain said roads has greatly exceeded the amount contained in the prior resolution, with the county incurring amounts greatly in excess of the amounts collected. And whereas the roads as originally constructed did not comply with county standards, and the prior resolution incorrectly cited KRS 179.470 as the basis for such resolution. And whereas the courts have stated that a public road is any road that is open for use by the general public, and it can be established through statutory means, dedication, or prescription. In contrast, a county road is a specific type of public road that has been formally accepted by the fiscal court of the county as part of the county road system, pursuant to Kentucky Revised Statute 178.010. And whereas KRS 178.010 prevents a fiscal court from accepting a road as a gift unless said road is constructed to minimum construction standards established by the fiscal court after July 13th, 2004, and whereas KRS 178-010-1B, county roads, are defined as public roads that have been formally accepted by the fiscal court of the county as part of the county road system, and whereas Oldham County has never accepted the aforesaid roads into the county road system, as the landowners in Oregon Creek Farms subdivision retain ownership of said roads. Now, therefore be it resolved by the Oldham County Fiscal Court that the Oldham County Road Department shall no longer maintain the roads and abutting areas known as Ridge Road, with the exception of the 1,265 linear feet of asphalt paved roadway starting at Oregon Creek Road and extending northeast, which is current within the Oldham County Road Maintenance System and will continue to be maintained as such. Oregon Circle, Hillvale Road, Springvale Circle, Ridgeway Circle in Oregon Creek Farms subdivision, as said roads do not meet the standards to be taken into the county road system and have never been formally accepted by the Oldham County Fiscal Court as required by KRS 178.010 and all other applicable statutes. This resolution shall become effective upon its passage according to law, dated this 19th day of August, 2025. And Judge, with that, I would like to call on Jim Silliman, our county engineer, to provide us with some information about this situation.
Good afternoon.
Okay.
Judge, let me just ask, we got a second on this motion?
Is there a second?
Second. I'll second.
All right.
As Magistrate Jeffries stated, I'd just like to give some information to help you in your decision-making process, because as Mr. Cray and Harrison have both, and the others have pointed out, there's a very unique history to the development and current status of this road. And again, want to give you the background that we have discovered, we being the engineering department, in our records in fiscal court, engineering, and other departments of the history and the development of this road. So what you're looking at right now is the general area in the northeast portion of the county. So you're aware of these are the roads. This is Oregon Creek subdivision. Zoomed in a little bit more with the parcel lines so you better understand the layout of the lots. So again, this area is the Oregon Creek Farm subdivision. And I think Mr. Harrison mentioned a portion of the road, again, to add to its uniqueness, there's a portion of this Oregon Circle that is platted. You see that what would appear to be a roadway, but it's just platted but not constructed. So for your awareness, the other roads are what we're talking about, the actual constructed gravel surfaces. So when we start getting into the history of the road construction, we understand these to be constructed probably of about 7 inches of gravel. That's how the plans that we have on file, we have, I believe, sections 1 and 3 construction plans on file, and they show a typical section with 7 inches of gravel. Whether, the question was asked of us what the planning requirements were at the time. We don't have a copy of those. The question was, was there a planning commission, and were there pavement design requirements? Again, we know that there was a planning commission then because we have records of some of their meetings, and whether there was a pavement design standard, we know that there must have been one because in 1972, in May 23, 1972, the developer of Oregon Creek Farm subdivision asked for an exception to the pavement design to eliminate the asphalt surface portion and just construct this roadway as gravel. What we see in our records is that the Planning Commission had that hearing, made a decision to refer it to fiscal court for a further decision. The the fiscal court hearing for that decision, we see a notice of it in the Oldham Era. There's a clip from the Oldham Era that identifies that this hearing is going to happen. But when we look at the actual meeting minutes in the clerk's office, in the county clerk's office downstairs, there's no mention of this discussion. So we just don't know what happened. We actually looked through a couple years to see if maybe it got put off, and we looked through a couple years of the minutes and did not see anything. So again, it came before, and when I say it, the request to build the roads to a accepted standard with no asphalt was presented to Planning Commission. They referred it to fiscal court, and we have no idea what the fiscal court decision was on that. What we do have are the Section 1 and Section 3 plans, and again, uniquely or interestingly, they're stamped as received. They're not stamped as approved, but they're stamped as received by the court or Oldham County Planning Commission there. So as we move forward, that's the road construction history that we know. Start looking at the maintenance history. In July 20th, 2004, there was the agreement between Oldham County Fiscal Court and the residents of the Oregon Creek Farm subdivision to establish this maintenance agreement where the residents pay $125 per lot per year. There's approximately 60 lots, which results in about $7,500 annually. We were made aware by the road department that over the past couple of years and this year, which they were documenting, that they spent somewhere between $30,000 and $38,000 on that road in their visits to do maintenance. So that is where this really came to question at the road committee. I think it's interesting just to present all the information we found to you. In March of 2005, there are fiscal court minutes that state that the road committee was presented with the Oregon Creek Farms request for the county to take their roads into the county road system using House Bill 199. The road committee recommends that fiscal court continue with the established policy. So again, we don't know the background, but for some reason in 2005, this question came up to bring the roads into the county road maintenance system, and it was decided not to go any further. In 2014, if you heard Magistrate Jeffries mention in the resolution, there's a 1,265-foot portion of the road that's accepted from the resolution. That's because in 2014, that portion of the road, which is a steep entrance off Oregon Creek Road, was paved, utilizing $26,100 from, it was a check from Oregon Creek Road Fund, and that combined with county funds was utilized to pave this section of road and provide drainage improvements, culverts, roadside drainage. And again, and the reason, if we look at those minutes, it was done, it says this segment of road was improved to increase the safety of emergency vehicles and other types of federal, state, and county vehicles such as fire trucks, school buses, mail trucks when entering or departing Ridge Road. But again, that was that first 1,265 feet. As far as taking, Judge, you were mentioning what our process is now for taking roads into the county maintenance system. They should be constructed to a county standard. And if we have these roads that are legacy roads and residents are asking them to be brought in to the county road maintenance system, they would come to us with a petition of at least 50% of the residents of that subdivision. And then we begin our process of taking it in if it's been built to the standard. The cost associated with bringing the road up to the county standard should be borne by the residents in accordance with our procedures. When we started looking at this matter, we did conduct an assessment to determine what the probable cost would be to improve the road. And these are very preliminary numbers. We just wanted to put together to have an understanding of what the cost might be. basically in the yellow would be the amount to bring it up to a county standard that includes the 5 inches of asphalt and 9 inches of DGA. It doesn't include all the shouldering, potential utility improvements and drainage improvements. It's just looking at the pavement section to bringing it to the correct width and thickness. Just doing the math on that is over 1.5 million. So we've been discussing in committee meetings about this, that really the realistic cost would be in excess of $2 million to include all those other factors. Understanding that that's a steep price, that's a significant amount, especially distributed among only 60 lots. We wanted to look at some alternatives. So we did look at if we were just to resurface or pave the road over the existing gravel at the existing width, not bringing it up to the county standard width. You're still looking at about $500,000. Another alternative would be to potentially utilize what's called cement stabilization, because if we're experiencing potholes and issues with the subgrade, stabilize it with cement and then put an asphalt cap over it is one solution. And just doing that, which is, we'll say the bare minimum, is still about $150,000. The challenges with these alternative numbers, the paving over gravel only and the cement stabilization, is they still don't meet the county road standards. So technically, even if those measures were implemented, I don't know that the fiscal court could take them into the road maintenance system because they don't meet the county standard. For your awareness, just for the matter of this hearing and public notice, we did publish in the Oldham Era on August 7th for today, and supplemental signage was placed in the vicinity of the Oregon Creek Farms subdivision on July 24th. If you have any questions for me, I'd be glad to answer those.
All right, anybody have anything for Mr. Sullivan? Magistrate
Woosley. Mr. Sullivan, are there any other subdivisions in the county that have an agreement with the county like Oregon Creek does?
Not that I'm aware
where
of.
we would contract to maintain the road?
Not that I'm aware of.
And we've had this contract in place for 21 years, is that correct?
Since 2014.
2004?
Sorry, 2004, yes.
Okay.
Thank you.
Would it not, in your opinion, and this is in my district, so it's personal for me, but in your opinion, would us not maintaining this road devalue their property that they've now gotten mortgages on, they've bought it property, they've built houses on, and now we're telling them, we're telling their insurance company, we're telling their bank, we're no longer going to maintain this road that we have now for 21 years that you received this mortgage on because the county maintained this road?
I don't think that's a question for me. I'm here for technical.
Judge, could we ask our county attorney, Barry Baxter? I think he has researched this quite extensively, and I think he could probably answer that question better than our county engineer.
Mr. Baxter.
Well, Judge, I don't know if I can answer that question. What I was asked to do was to look at the legality of spending county dollars to maintain roads that are not part of the county road system. Mr. Stillman, don't leave, because I'm going to, you didn't find any evidence that would indicate that these roads had ever been accepted into the county system, did you?
That's correct. I did not.
And so I did research, and because I was trying to find a solution for this problem, I reached out to Rich Ornstein with CAECO and asked him the same types of questions. And the first thing to be clear about is a public road is not a county road. They're not the same thing. In order for a road to be a county road, it has to have been accepted into the county road system. And if it's not of record, it has not been adopted into the county road system, because the fiscal court is the court of record under KRS 67100 per Mr. Ornstein. So in other words, in order for this to be considered a county road, the county would have had to have accepted it into the system, and it would have to be a matter of record in the fiscal court's records, which we cannot find any indication that that is the case. So we're talking about public roads. The fact that the Planning Commission may have made a recommendation to the legislative body, the Planning Commission's not a legislative body. It's the Planning Commission. The legislative body is this fiscal court, and the fiscal court is the body that has to approve that a road that's been dedicated to public use becomes part of the county road system. So what we are left with is public roads. My research indicated, and Mr. Ornstein confirmed, that the county cannot accept a public road into the county road system unless that road is built to county standards. And the KRS 179-470 cited in the resolution has been rewritten since it was utilized in 2004 till now. It's sort of changed what the criteria were, but it has been consistent in that in order for the county to take these roads into the county system, they have to be built to county standards. When I asked Mr. Ornstein, I know there's been some discussion about, is there some way the county can maintain these roads? His suggestion back to me was the road taxing district, which obviously we've talked about that. And as a road taxing district, with the rate that they could impose, they're not going to generate nearly enough money that is necessary and has been necessarily expended by the county on an annual basis to be able to defray that cost. So, all I'm telling you is what my research was, and, I don't have a vote, I don't have an opinion. I can tell you that, I have looked for ways to see if there's some other way that we could resolve this problem without any particular success. And, that the statutes are pretty clear that we can't spend county funds to maintain roads that are not up to county standards. We can't, there's just no way for us to do that. And that's kind of how I was asked to weigh into it.
Magistrate Woolsey.
Mr. Baxter, was the agreement that we made in 2004 legal at the time?
In my opinion?
Yes.
It did not comply with the statute at the time, no, sir.
Okay. If we were to enter in a similar agreement today with this neighborhood, what would something like that need to look like? So that we can collect this money instead of them doing a taxing district, which, as you said, is not going to generate enough money for them to pay or stock up enough money to pay to have the road rebuilt to county standards.
Well, I think the problem is, if you go back to the estimates that Mr. Silliman gave you, I mean, the number was a $1.5 million. And I don't know how many lots are out there, but it's around 50, right?
56, yes, sir.
60.
I think it's 56. 57.
57 lots. So you divide that into $1.5 million, that's a lot of money.
Yes, sir.
10 cents is the maximum.
Well, it comes, if you take 180,000, because I built in, 1.8 million, and I just built in a little bit more, and I divided by 60, so I rounded them both up a little bit. The net nets out at about 30,000, unless my math is all wrong. 30,000 per lot. And then if you can break that up for each property owner and put it into a mortgage or add it to their mortgage or it goes on the tax roll, that we figure out a way to get that, then it's going to cost each person $30,000 per lot to get that done, which would be paid off over a period of years. And I'm wondering if that's not a way that they can get that done. And I don't know if the county is legal to oversee it, or if they contract with the company to do it, and then we oversee that work to make sure that it's done to our standards. That each lot owner, so if you're sitting there with owning 5 lots, then you're going to be at 5 times 30, whatever that comes up to.
50.
And that gets pretty much. But, and just a show of hands, are a bunch of you out there owning more than one lot? Or does everybody just own one lot? You got more than one. Okay. Most of you just don't, how many own just one lot? See, there's a lot of people that own just one lot, so they're only doing that, and then you spread that out maybe over a 10 to 20 year, and you pay it on your tax basis. That's just what I was doodling with, so I'm gonna stop talking right there.
Mr. Baxter, we brought that up at one point as a resolution. So basically, the county fronts the money, we put it on their tax bill over a 20-year period.
Well, and so, you know, this statute, KRS 179-470, is very confusing. One provision of that statute does seem to indicate that that can happen, but the problem is we don't meet the criteria for the statute, which says in counties containing population between 80,000 and 115,000, and a city with a population equal to or greater than 20,000, or in counties containing a city with a population of less than 8,000 and not a city that equals or exceeds 8,000.
Okay. Can you raise your mic on?
Yep. So the statute basically, we just don't meet the criteria for the statute because of population. The population, we don't have enough population in the county. We're less than 80,000. And we have a city that has more than 8,000 in it. So we just don't meet the criteria of the statute. It goes on to talk about the county being able to be reimbursed for the cost of maintenance and services by the abutting property owners, whose proportionate share of the cost of maintenance services shall be added to the owner's county tax bill and collected in the same manner as county taxes. But the problem is that under those that's not contained anywhere else in the statute. It's only in, and you'll have to talk to, you know, David Osborne or Jason Nemus about why they picked those numbers to have that exclusion in there. But you know, they put this one provision of the statute that would allow for it to happen, but we don't meet the criteria.
Manager Jeffries.
Yes, to follow up with our county attorney's opinion, I mean, he has talked to Rich Ornstein, and, you know, I think, you know, all of these options that are being discussed don't fall under the statute or whatever. I don't think legally we can do that. You know, I think he's outlined that we don't meet the 80,000. We don't meet the city number that qualifies us under that particular statute. So, you know, it's a tough situation, but I think that, you know, just because we have been doing it for several years, since 1972 or whatever, doesn't make it legal, and it has gotten extremely more expensive to continue to maintain the roads over there in Oregon Creek. And I think that, you know, with this resolution, you know, we have to make a break. Now, if they want to set up, you know, a taxing district or a homeowner association or whatever and do this, I think that's on them. But I think the county, under KRS statutes, you know, we need to get out of this. And that's you know, and I think that's the conclusion that road committee came to. I mean, it was a 2-to-1 vote, and to recommend to the court that we accept and pass this resolution.
All right, Magistrate Hawkins.
Jim, was Oregon Creek Road constructed to county standards when you said that it was paved recently?
Only a section. There's only a section.
The section, was that section?
The 1,265
Yep.
feet, I don't think it meets the width, because it was, if I remember correctly in the documentation, it was built to 16 feet, and that's narrower than our current standard. There were drainage improvements made, and there was pavement surface added, but I don't think it would currently meet our county standards.
So was it you that was talking about a road taxing district? That would be something that their taxes would be contained through the
Mr.
sheriff's
Baxter knows
officer?
more about the road tax.
How does that
road
work?
taxing
Would it,
district.
would those, if they created a road taxing district, would that money be gathered through the sheriff's department, right? And then just sort of maintained in an account? Is that how that would work?
Well, they get the money. I mean, other situations, that you can go out and borrow money from a bank. They will bond you, and you have to use the money generated by the taxing district to repay your bond payment. But again, the issue gets to be if they're going to raise $6,000 a year, and that's based upon the max tax rate that they can charge per statute.
Okay.
That creates a constraint.
I remember we talked about this when we were talking about the same exact thing for Green Valley in my district. The roads didn't meet the county standards, therefore we couldn't accept them into the county standards, and it's into the county maintenance system. And I feel for Magistrate Woosley because it's a very frustrating situation.
Magistrate Tice.
I
He was
recalled
he go.
that Kevin Eldridge had worked on this. Did you get an opportunity to talk to Kevin? Can you
Yes.
refresh my memory and tell me what he did and how's the difference?
I can. I did reach out a couple of meetings ago to talk to Kevin Eldridge. He had no recollection of doing this, working on this at all. He said that, he remembered, kind of what some of the issues were, but he said he did not do anything personally to try to work through and come up with a solution for Oregon Creek. He was not aware of anything that he had done.
Excuse me. I was not meaning Oregon Creek at all. I was talking about Borwick Farms, which was in his district. Can you hear me? Okay. At that time, that what he did, we had a couple of roads in there. When Borwick Farms was one of the first subdivisions built, after 71 was put in, first major subdivision in our county, and it was all in gravel, similar to the situation you all have got. And that what he did in Borwick Farms is they had a couple of roads, and I think rather than acreage, their deal was put out on frontage. So in other words, whatever amount of frontage, if we had a road that was 100 foot and we had 5 houses, then you would not pay 1/5. You would pay whatever their frontage amount that ran across in front of your house. And at that point, they put together a package, and we were able to pave those roads, and then my recollection was it was more than 50%. It was something like they had to have a 61% of the property owners that would vote to do this. And then they came forward with that. Once they acquired that vote, then they could put it in, and then each property owner would pay whatever their share was. And then they would put it on their tax roll. They would take a mortgage on the property. Like I'm sure that whatever your house is worth, it's worth a lot more than it is now. And if you all get your roads improved, that's going to be even worth more. So rather than whatever you're putting in every year to help us do a road maintenance things, which we can't do anymore and should not have been doing this long, that you would have that money to pay yearly on it'd raise your mortgage payment a little bit each month, or what you had to pay. But the point ends up happening, once you do this, then at that point, and if it's put into county standards, once that's done, then we're going to carry the bill from there. So you all don't have to pay any more money each year, and I don't know what you've been paying in a year, whether it's been $100 a piece or it's been something more realistic like $1,000 a piece. But that would give you all the opportunity. And as I'm talking and thinking, this could be a tax, attorney situation that you all could go to and try to get somebody to handle this for you. Our property, attorney that could put this together. And I know we've got those kind of people in the county.
Judge.
All right, Magistrate Likens was next.
Thank you, Judge. I don't know if everyone here knows that the maximum taxing district rate is 10 cents per 100. So if your house is worth $500,000, that's $500. That doesn't go very far on getting this done. Can you tell me and tell the audience here what our county standards are currently for roads, Mr. Silliman?
And then tell us what those.
I would be better off getting the book to tell you exactly what they are, but if I recall correctly, it's 4.5 or 5 inches of asphalt with on top of 9 inches of dense grade aggregate. I think for that subdivision or that road type use, I think it'd be 2 10-foot lanes. There's drainage requirements. So again, when we're looking at the county road standards and coming up with a ballpark estimate of what it would cost, those are the approximate dimensions that we're looking at.
Thank you. I was involved in getting those standards done when I used to be county engineer, but there's 9 inches of dense grade and 5 inches of asphalt.
Okay.
Is what it is. So currently, do we accept any roads into the county road system that are gravel? I know we
Currently?
have some, but do we accept any new ones in?
No.
Okay.
We did. We,
Okay.
But
I remember this coming up in front of fiscal court, and the legal term escapes me, but it's artificially enrich. It means that somebody else in a subdivision in Oldham County, when they buy a lot, the road and the utilities and everything is in the price of that lot when they buy it. They don't buy a lot on a gravel road the same price as you buy a lot on an asphalt road. So we would be artificially enriching that entire subdivision if we spent county money on it. And the reason our standards is now 9 inches of dense grade and 5 inches of asphalt is so that we don't encumber the rest of the county to maintain someone's road that we bring into the county road system.
Judge, I have a question.
I think Magistrate Hounds was next.
We're looking at this thing wrong.
I guess I am.
Several years ago, when I lived in the Ashbrook subdivision, the entrance to Ashbrook, dumbest thing in the world, the entrance to the subdivision was not a county road. And if you went to the T in the road, you went to the left and went to the right, it was not a county road. I have to go back and count. It was at least 10 houses up from mine, became the county road. So we had to take, and we did it by road frontage, and we had to pay to bring the road from the entrance to past my property and past others up to county standards. And in order to do that, we had to put down asphalt. They did core sampling in the road to find out how much gravel was underneath of it, and then they capped it, and it became brought into the county road. But that cost was borne by the neighbors by linear foot or frontage. I guess where I am is that part of the problem we have is that these residents that bought these pieces of property, the developer didn't build the roads the way they should have been built and turn them over to the county like other neighborhoods have done. And now, X number of years later, they're having to deal with that issue. I guess it would be nice if we could come up with a means, and Magistrate Tice was going down a path that I was going to go down. But if you were to do that, using your $30,000 number, I don't know how we would get paid to start the process and then be able to collect the process. There's got to be some legality stuff that has to be worked out in there. I'm sympathetic to the problem, but also I know we can't improve the road outside of the scope. I mean, just like others have said, it's got to be brought up to the county standards. I think that's where the rub is. The road's not brought up to the county standards, as Mr. Stillman and others have stated. So until the road gets brought up to the county standards, or there's a plan to get it brought up to the county standards, I don't know that the court has any other options. I mean, we have to follow the KRS.
Magistrate Logston.
I think sometimes you got to step out and look back in. We're wanting to bring these up to county standards now. How many of y'all would be okay with gravel still? Why
gravel,
do we have
keeping it
to
gravel.
keep them at our county standards now? The subdivisions, I don't know how many subdivisions in Old County are still gravel. 5, let's just say 5. I really don't know what they are. Why can't we make a standard for any other subdivision that's going to be built in Oldham County from now on out till whenever will always be built to county standards today? Why can't we have a county standard for gravel? Just, it doesn't have to be 20-foot wide. They could be the same width they are now. Nobody's fussing about how wide they are. Why can't we do a gravel road standard for these 5 or 6 subdivisions that are there and make that our standard for gravel roads? Again, there will never be another gravel road that's turned over to the county that's gravel. It'll all be asphalt. I'm just trying to solve a problem here. And I just think sometimes you have to look back in.
Measure Jeffries.
Magistrate, I don't think we can do that. We've heard our county attorney, and he's talked to the CAECO attorney, which is Rich Ornstein, and, we're, the resolution that's on the table today is that we, as a county, with taxpayer money, have to get out of this situation. Now, I'm not saying there's not things that we, that they can do as homeowners and as property owners in that area, but I don't think that the county has any legal bounds or whatever that we can pursue that does not would allow us to do that. I mean, I think that we're when you get into having a special something for a particular area of the county, I think you open up a whole can of worms there that I don't know that we as a court want to get into.
There's not very many gravel roads left in Oldham County.
We don't have an ordinance today. We would have to take and work and approve this ordinance to your theory and then create an ordinance later on.
My theory is nobody said that they would not help bring the roads up to a standard, that it would not cost the county any money. And if we did, we could do like I had rental houses in Country Village. I had to pay, I don't know, $100, $200 a month for 10, 15 years until that bond was paid off. In fact, the county didn't keep track of it, and we kept paying even though it wasn't even, the roads were finished. But I'm just saying, there ought to be a way to make this work. Just keep them as gravel and not make them any wider, not bringing them up to county standards for asphalt, but just a county standard for gravel road that was built back in 1972, just so that we can maintain these roads to where they are now.
Are you saying that,
apply that to the
is your recommendation or your suggestion include moving up to the realistic cost of what we're spending now? In other words, everybody here in Oregon Creek, they're going from $150 to $1,000 a year. We're spending, $40,000 a year there right now. So that's, we're not, the $150 deal is gone. We can't, everybody else in the county is not responsible for, underwriting the road maintenance in this subdivision. It's.
Well, there's only so many roads left in Oldham County.
I'm sympathetic to the problem, but we got to be realistic. Even if that solution worked, Mr. Baxter, would that work?
But if I was president for the day,
collecting
I wouldn't finish.
$1,000 a year from these people, and then what happens if somebody doesn't pay?
You condemn their property like you would in a bank.
Probably a lien.
But Judge, I'm not finished. What my whole point is, we're trying to bring these up to today's standards. They don't have to be brought up to today's standards.
We're never going to get
How much did we spend last year on gravel on the road?
I believe the road department, and they tell us around 38,000 plus.
Okay, so.
Okay.
So if
I heard somebody laugh, but we can show the bills.
3 days, 3 trucks, 3 men, 2 men, 3 days, 3 trucks of gravel. Gravel costs $700.
Well, maybe okay, if that's the case, then let's dissolve this and let you hire the private contractors to pave your roads. And, let's get us out of it. You all hire your own private contractors, and it'll be a lot less expensive
There ought
that
to
way.
be a way to fix this
That's the
problem.
case. If that can be done for less,
It'll be
you
done.
take it. Huh? No, it's not our road. It was never approved by the fiscal court. Planning commission and stamps on things are not the same as the fiscal court. I think that was made clear. Oh, come on now. Court is discussing. Who's Magistrate Woosley?
I had a lot to say, and now I've gone blank here. A few things I want to address. The county has taken in a gravel road very recently into the county road system, Hidden Valley, which we spent about $100,000 on just a few months ago doing some work on. We've taken in a portion of Ridge Road that doesn't meet county standards, but we've taken it into the county road system. So we've already set a precedent of not taking in county roads that don't necessarily meet our standard. This subdivision is the one unique subdivision out of the whole county that has an agreement with fiscal court. Legal or not, for 21 years, they've had an agreement with fiscal court where we've collected money and done work on that road for them. They've lived there with that thought, that security, that fiscal court, that they're paying fiscal court to maintain the road. We should have been keeping up with inflation over that amount. We haven't. It's not their fault. It's fiscal court's fault. My question is for fiscal court, we're about to dump these folks and give them absolutely no way to fix this road because they can't do it currently. They can't create a taxing district because they can't raise enough money to pay the mortgage or pay the bond to fix the roads to county standards. There's not enough property value in this farm for them to generate that kind of money. We have, I think, 5 subdivisions in Oldham County that are gravel. Magistrate Hawkins, you have a huge one in yours. Why can't we create a committee and not find reasons not to do it, but find reasons how we can pave those roads or get them to some kind of standard that we would accept, and put the lien back on the property owner so they're still paying for it. We pay for it up front. They'll pay for it in the 20 or 30 years that we could do that. I know you're going to say we can't, but I'm asking fiscal court, let's find a reason to do it. And if we have to lobby legislature to get it changed, we can. We're going to meet this 80,000 probably in the next couple of years anyways, but on the population side. But let's create a committee to find a way to fix these 5 subdivisions so that we're not having this problem long term.
Magistrate Jeffries.
Yes, Mr. Woosley, the problem is here, I mean, we've been discussing this since January. I mean, it's not something that we have taken lightly and something that we have, just, we're going to get out of this at any cost or whatever. But, we have, our county attorney, along with the CAECO's attorney, has looked at this legally and what we can and can't do. And what you're suggesting, I don't think is legal. And I'm not an attorney, and I defer to our county attorney. But, just because, if we, I think we need to approve this today and then see if we can't work with these folks or whatever. But I think we've got to get out of the liability. We have not spent any more money over there since we really got into this process, because we don't think we were legal to do it and spend taxpayer money on private roads. Now there's, you can argue private versus public, and that kind of thing. But I think our councils have told us that these statutes are not, we can't continue to spend public funds on private roads. And so, I think we need to vote this, to approve this resolution and then, try to work with these folks and try to work with, if there's other areas in the county that need to be looked at or whatever, let's do that. I'm not against setting up a committee or a subcommittee or whatever to look at this, but I think that legally we've got to make a decision and we've got to get out of this, what we've been doing for, since 2004 at least, because it's not legal. And that's my thoughts.
Magistrate Likens.
Yes, Judge. I agree with Kevin, but I believe out of the
Which
200
Kevin?
subdivisions, you're taxing my memory, but I think it was Fiber Farms that we did this on, because I was the county engineer back in 96 and 97, that we did do it by road frontage.
Measure Tice.
That's where I was coming from in what I was saying. Let's find a way to do it. We have an engineer. We've got a CFO who can figure out the money. And let's go out and figure out, and and that's our time, and we just do it. But it comes down, and you talk about a group, you've got your magistrate here and somebody on the homeowners group. Once we run some numbers, you figure out how much it's going to take, and I think road frontage is probably right rather than a lot. But you run the numbers two ways, and you just do that. That's where I was coming from. Then you figure out what the property's worth, and you go to the mortgages, and then you figure out a way. Then you bring in an attorney, and you take it to the people that got holding the mortgage on the property. I think we can move forward a little bit and not break any laws, but we can help them move through the process because we have the people already employed in the county. So they don't have to go out and pay hundreds or thousands of dollars to hire an engineer to go out and figure what time we'll donate from gyms or whatever. So.
Magistrate Dye.
Thank you, Judge. I know all of you out there are kind of ambivalent over the way that, you all are getting what I guess can be recognized as a pretty sweet deal on taking care of your road for all these years. Now, I'm not against sweet deals, okay? I don't think I'm the bad guy here. But I'm going to tell you a couple of real quick anecdotal stories here. And some of them happened to me when I moved to Oldham County. And you'll understand that sometimes these things happen and you don't know they're going to happen until they happen. I live in Glen Oaks, and you may or may not know Glen Oaks is split in half between Jefferson and Oldham County. And I live, of course, in the Oldham County side because I wouldn't be sitting on this bench if I didn't live in Oldham County. Now, on the Jefferson County side, there's, it's all sewer, MSD. On the Jefferson County side, well, it's the MSD sewers. On the Oldham County side, I said, yeah, sure, we'll take, what, this did not occur when I was a property owner. This occurred before I was part of it. Yeah, we could take care of that. We can pull that up. We can take the flow off of that other side. Well, lo and behold, I moved in. I got to talk to my neighbors one day, and they started talking about their sewer bill. Guess what? I didn't realize this, but the sewage from Oldham County going to the MSD plant on Hit Lane cost twice as much as the sewage going from Jefferson County. All in the same pipes. I don't know how they kept the Oldham County sewage separate from the Jefferson County sewage, but I was paying twice.
It's 50%.
Yeah, right. But twice is twice. I don't care what it is. So, and then that was when we got rid of the environmental authority, that particular problem went away. About 20 years I paid twice. All right, the second thing is, there was another little law, that a little agreement was put in place. I'm not exactly sure if it was a law or agreement or whatever, but Oldham County's got a EMS, and I pay on my tax bill an EMS fee. Lo and behold, Worthington Fire Department, they merged with some other fire departments and made Middletown Anchorage. How about that? I'm paying a EMS fee to those people at the tone of 10 cents on 100. So there's another little surprise for you. And, and what we're talking about with you guys here, you all as a group, not just the ones that are here, you all as a group are going to have to figure out what you're going to do. Because, the day of the county supporting this program is pretty much come to an end. Now, you can go the asphalt route and upgrade your whole subdivision. Maybe you don't want to put that money into your property. That you'd be a no vote on that. Maybe we could work something out somehow legally where you all can go the gravel route. But whatever you want to do is you want to make sure that it's majority vote for a lot of different reasons. I heard someone say at the last court of the court before that some of those lots have been sitting there for years. And, for whatever reason, somebody's holding on to them, which is fine. But those lots, I don't know if they're priced at residential property taxes or farmland. But the thing is, you're going to have to come up with is: do I want to improve my property with the asphalt route? Do I want to leave it status quo, the way it is now, basically? And the one other thing I wanted to tell you now, this Spring Hill subdivision did the same thing when they were a private subdivision, private roads, and they were not built to county standard. My best friend lived there, and one day they decided, it's in Crestwood, when they decided, now we want to get out of this road district. So they got with the county and they said, okay, you got to do this much to the road. You got to make it wider. You got to do this. You got to do. I don't remember all the particulars, but he said, at the end of the day, when all the equipment was gone and all the grass grew back and everything, he said people actually forgot about the fact that they had those narrow roads because they like the wide roads. So I don't know what the answer is for you guys, but I do appreciate you coming here and voicing your opinion. But it's going to have to be something y'all are going to have to come up with yourself because. And these people on this bench and the judge and his staff would do whatever they can for you. There is a solution, and we're not going to get the solution between 2 and 4 o'clock today.
We don't ask questions.
We don't do that.
No,
but you can come up here and make the.
I'll let you come up to the microphone, but we're.
We all want to hear what you got to say,
passed
but you
the
got to do it a
public
certain
comment.
way. Yeah.
Yes, I just get into county standards, whether we choose the asphalt or gravel. If you know that region, it is impossible. The terrain, the topography, there are 100-year-old trees. That estimate that you gave, 1.6 million, I believe, or something to that effect, is completely outdated. It's not unrealistic, honestly. It was to county standards because they put drains in the original 1972 building of the road, actually.
Mm-hmm.
They're still sticking out, actually, currently, right now. I don't see how we would pay to get to county standards when it can never be that based on the topography. It's on ridges. And that's the biggest thing. We could never even get to 8 feet wide, let alone to county standards of, 20 or something to that effect. There would never be more than a 1-lane road. It's impossible.
But me not knowing all the things that you know and you guys know, you all know what's best for you.
I just don't know what the solution is.
I think you've already said that doing the asphalt route is probably not the route you're going to go. So put your efforts into some other things. But, you're a smart enough group to do it.
Okay, but we're, belaboring this quite a bit here. Mr. Baxter, didn't you reference a state statute that prohibited us from fixing these roads up and putting it on the tax bill at this point? Is that right?
Well, Judge, I think the way the statute reads is the county cannot accept these roads into the county road system for maintenance purposes unless the roads are built to county standards. And the roads obviously are not built to county standards. So, I looked while, the former deputy or the former judge, John Black, is texting me during the meeting. I've had other people texting me during the meeting. I've looked to see if I can find. Everybody keeps talking about Fible Farms. They talk about other things. I don't have any statutory basis that I can see that puts the county in a position that we can front these funds. Now, if there's a statute out there and somebody wants to point me in that direction, Mr. Ornstein did not call my attention to it, and I made him aware of the problem and asked if that was a possibility, and he indicated we could not do that, and he again suggested, which I understand is not an acceptable solution, the road taxing district as the answer. So, I believe the way the statutes are written, it prevents the expenditure of county funds to maintain these roads.
All right, and that What about the idea that came up to creating a gravel standard for roads that are currently gravel?
Well, that's a brand new thing. I think that, that would have to be adopted as a part of probably the road standards for the county. Are they contained in the zoning ordinance, Mr. Silliman?
The road standards are currently in the subdivision regulations. And I think in order to do what you're talking about, we would need to do like what was suggested and form a committee to look at how we could establish a different set of standards for these conditions. Now, we've talked about this in road committee, and the challenge with that is that there are varying levels of roads that are not accepted into the county road maintenance system within the county that have asked to be taken into the road maintenance system, and we haven't done that, whether it's because they don't have a cul-de-sac at the end of them, or they don't have sufficient right-of-way, so there are some that are just shy of the regulations, maybe drainage improvements required, and they've decided not to go that route in order to be brought into the road maintenance system. And there's some more extreme, like Green Valley subdivision or Oregon Creek Farms. So not that we're opposed to challenges, but that's the challenge, is sitting down and establishing what this lower standard is that we're willing to accept and coming to terms with that. So I think that's how we would have to come to new standards.
Right, non-paved standard.
Or whether you want to call it a legacy road standard to bring it in.
Okay.
Right, but that would have to be done because the way I look at it, we have one county road standard, and that's in the subdivision regulations. And
Magistrate Woosley.
How did Ridge Road get brought into the county standards, the county road system, without meeting those standards?
I wasn't county engineer at that time.
I'm asking you now, county attorney.
I don't have any idea. I wasn't here. So, what I have been told, just anecdotally, was that the county did that as a courtesy, paved that section of the road as a courtesy because of concerns about emergency vehicles being able to get up that hill.
Right, and that's why it was done. Why it was done to a lower standard,
And we
don't
spent
know.
county funds on that road to help bring it to standard.
That is correct. It was a
The
cost
public
share.
safety, the public safety question still exists through the rest of the subdivision. So
That public safe-
if we could bring Ridge Road into the county road system and pay county funds to help bring it into the road system, we could do it with other roads.
Again, I think
If there was an ordinance back then, there's something now that's allowing us to do it, and that's what I'm asking for. Let's create a committee and find out how we did that.
Today, we need to pass this ordinance and then create the committee. I mean, we got to get out from underneath of this
We're not going
problem.
to spend any more money out there.
We got to get out from
We've been
underneath this
told it's
problem.
illegal, so I'm not going to let the road department do anything more.
We've not collected any money from them all year, because we only collected in November, so we're not collecting any money from them anyways.
I think that there's two pieces. One is, and Mr. Baxter made the comment, and somebody else made the comment too. If there's legislation that needs to be changed, then start making trips to Frankfurt. I mean, that's how it's going to be changed. That's how the law is going to be changed. Not at this level, because we can't go around the KRS. And you made the comment about that it's legal. We need to stay legal. We don't need to be doing anything that's illegal. It's just opening ourselves up for a can of worms that we don't need to be going down.
I agree.
We've already been down that path once, and we got lucky.
We went around that KRS when we brought in Ridge Road, the section of
I
Ridge
don't know anything
Road.
about Ridge Road. I didn't know even know it was part of the county road system until you just mentioned it.
Judge, I understand we cannot keep going forward from KSR or KRS regulations. However, we are the county, we set county road standards. We can take these gravel roads that are left in the county, if we're not going to do them, and we can make the roads from the way they are right now. Now, I don't know about Green Valley because they were in such bad shape. I don't even know how you fix those. But Oregon Creek, we can just put a standard in there for what those gravel roads will be kept at. And then you can go to a taxing board or however and tax those individual property owners for the gravel roads up to maintain them. I understand we have to do something today with where we are because we cannot go against the law. I mean, can't do it. But why can't we have the county start working on?
I think anybody's against what you're saying. I don't think anybody's against that part.
That's what I'm saying. There's where I'm going.
The majority of the court is in favor of doing something after we take care of this ordinance. But this ordinance has to be taken care of.
Judge, so here's my issue with this. If we do away with this today, they can't create a taxing district to generate enough money to pay the bond if they went legally and did a taxing district, because they can only do 10% of their, hang on. So with an agreement like we've got in place, we could still go back in and modify what they're paying a year. And if they're paying $115 a year, if we determine that number needs to be $500 a year, well, we have an agreement in place right now, so the only thing we're having to change is the dollar amount. We're still collecting it through the sheriff's department that's going to fiscal court. They're still going to elect somebody within their committee to tell us when a road needs to be repaid or repaired. So we have the mechanism in place right now to collect the funds that we could collect more than what they could as a taxing district. And
I didn't think that was still legal because of the change in the KRS that happened years ago.
so let's figure out a way to make it legal. That's what I'm saying. Let's not do away with this.
Legal today, Kevin. That's what we're all saying.
Let's not do away with the agreement. Let's find out a way to fix it. That's what I'm asking.
Mr.
We're going to have to find a
Baxter,
way to do it because they can't collect enough taxes to pay for it.
I don't think anybody's against it. I think the problem is we have an ordinance in front of us that is in violation of KRS. We need to take care of that ordinance today. I haven't heard anybody on the court. And you guys gals can raise your hands. Nobody is against taking the next step. But today, we got to take care of this ordinance. And then you can bring it up in the next 5 minutes. We can put together a committee or whatever. We can start working on the solution. But today, we have to fix this ordinance. That's what's in front of us. Adding the other stuff that you're talking about, I don't even know how we could do that because this has been noticed in the newspaper. And that, to me, would be a substantive change. I'm not an attorney. I'd have to ask Mr. Baxter that. But I don't know how we can make a change like you're suggesting.
It may not be legal today, but it was legal in 1972 when they grandfathered it in.
Things were legal in 1972.
Which I'm saying, it's still in effect. It's still grandfathered in, and we're going to do away with it. And now we're not going to have a mechanism.
So the change in the KRS that happened.
It was legal when we passed it in 1972. So it's legal today because it was grandfathered in.
Where's the grandfathered in?
Why wouldn't it be? We're still collecting the funds.
Doesn't make it grandfathered.
So have we been illegally collecting funds from them for
Judge,
years?
Can I ask for a call for the question? Is that appropriate?
all right, let's, I still would like to ask one more question. If we go ahead and, stop now, that doesn't stop us from forming a committee to look and see if a county road standard for gravel can be developed, correct? All right, and then I believe that if we had one, it would be up to the people in this subdivision to take it upon themselves to get that gravel standard met before we would take it over and continue it from that point. Would you agree to that? Does everybody agree to that? In other words, we've got a few gravel roads around, and I don't know how Hidden Valley, I knew we had some problem out there, and one of our snow plows fell off the road on Hidden Valley, and I think we had to go out there and pull it out. Am I correct on that?
The equipment was in Oregon Creek Farms, I believe, that it went off the road. Hidden Valley was it's a shorter gravel road, but it's a gravel road with challenging terrain, very similar.
Right. I mean, these are...
And it was taken into, I think I've got it on here, it was taken into the road maintenance system is the difference between Hidden Valley in 1995. So we have been able to perform maintenance without that agreement on Hidden Valley because it was taken into the county road maintenance system. Why it was taken in 95, I can't tell you. And yes, we did work to repair stream stabilization that was encroaching on that road recently using funding from rural and municipal aid from KYTC.
Okay. So why don't we, say go ahead and pass this resolution, but we can create a committee to develop a gravel road standard for what we might call legacy roads I'd say no future roads in the county. All the homes in these subdivisions that are built on gravel roads were all built without the expense. The developer put something in there, and you didn't pay for that, or your predecessors didn't pay what you would have paid if you'd have been on a road up to county standards. So, nobody thinks of that later. They just say, well, it was the cost of my house. No, your house was cheaper because that expense was not added into it from the very beginning. But we'll get a committee together and get a gravel road standard. But I think, from my point of view, residents, it'd be up to you to get together and you're going to have to meet the gravel road standard that's developed. We're not going to meet the standard for you. Well, we're going to develop a standard, and then you have to meet it. And if you meet it, then we'll take it from that point.
And we can't collect money from anybody in the neighborhood.
Oh, you can collect all the neighborhood. You get yourselves together and organize, and we're not your trustee for any HOA here. You can organize yourselves and work together if you can get together as a group. And you can have an attorney handle your money.
Hold on a second, Judge.
We called for the.
You're suggesting that we have to create an HOA just to follow your regulations for the gravel roads so that we can pay for it, right? Is that what you're saying?
I think if we create a gravel road standard, you will have to get yourselves up to the standard before we take it and go forward with it.
Fine. We've got 21 years of paying almost $7,000 a year. That's $140,000 we've already paid. I can guarantee you this county has not paid $140,000 in 21 years in maintenance.
I mean, that's a ridiculous guarantee. You can't begin to justify it. It's just an opinion. Come on, to say we've not done anything out there. Our predecessors have. I just told you, our people, road departments thought they spent about $38,000 out there last year. So, come on, we're trying to come up with a solution here for you.
So am I.
We're all sympathetic. No one wants to damage you all, but our responsibility is to everyone in the county to be treated fairly.
Okay.
And you've got a situation
And
here
I don't
that's-
want any of my tax money to pay for any other road pavement in the.
Well, then don't drive on any other roads in the county either,
Well,
So,
that's how it's going to feel to us. But question I had, can I ask one?
This can has been kicked down the
I know.
road year after year,
I ask
decade
one
after
quick question,
decade,
please?
and it can't go any further.
Can I ask just one quick question to Mr. Jeffries? Mr. Jeffries, the resolution that you read, did it not start out with the Oldham County would assist with maintenance? I don't believe that was in the resolution.
The July 2004 one.
He was quoting from a resolution from July 20th of 2004.
Okay. Yeah, it said, let me just read the first paragraph. Whereas pursuant to Resolution 0107-2040 adopted by this court on the 20th day of July 2004, Oldham County agreed to assist with the maintenance of certain subdivision roads, namely, and then it lists the roads in your all subdivision. But
point
that
being-
was in 2004.
Point being, that's assist. That's not pay for the whole thing.
Okay.
Assist means part of. It doesn't specify what part of it's going to be. We're paying $7,000 a year. You're paying $31,000 a year. That's assist. We're assisting, you're assisting.
That was a resolution that was drafted and passed in 2004.
Right.
This resolution would make that null and void if we pass this
If it was
today.
passed.
Correct.
If it were passed. Why does it need to be passed? You're paying your part, we're paying our part. Let's call it even.
The reason that we're considering this resolution today, as our attorney has pointed out, is because according to KRS statute, we cannot continue to pay taxpayer money towards private roads. So that's...
Is it really a private road?
Well, that's another argument that I believe has been talked about.
You're right.
It's either a private road or a public road, but it's not a county road.
Okay. Question is, would it be possible to negate your request at this point in favor of the committee that Mr. Woosley suggested to see about how we can
better fix this? The way, I think the county judge pointed out that we have not continued to pay for, road maintenance over there on your all's roads. This is not, this has been going on since at least January of this year, this discussion. Here we are in almost September, we haven't made a decision. I think we've got to get a decision made and where we can move forward. I'm not against, bringing a committee on board and looking at it through the road committee or whatever judge wants to set up to look at what some alternatives are. But I think as Magistrate Hounds points out, we have a resolution today that I'm advocating for that we need to pass. That gets us off center here so that you all have something that you can look at and we can work on. What happens
Okay,
if you do pass
wait,
this
wait, I think-
resolution?
I
We've got
think-
no recourse on this.
No, you're right, you don't. We're
Kicked to the curb.
Pardon?
We're kicked to the curb.
Well, you're
If
not
you pass
kicked to
this
the curb.
resolution today, we're done. You're probably
No,
going
we're
to throw
not.
us out.
We didn't say you were done. We said I'll appoint a committee to work on a gravel road standard, and we'll have to try to work to help to get it up. But it's going to be up to the people in the subdivision to get up to that standard before we take it back. I mean, this is for everybody in the county that's in the same circumstance, not just you all. I mean, they mentioned Green Valley. I mean, that's a mess out there. There's some that developers did not do the full job. I mean, and they sold people.
50 years ago.
They sold property cheaper, and it's always been cheaper because it's just the way it's gone. But we're inheriting this. But there's no one here that's not sympathetic with wanting to help. But we follow the law too. Okay, you want us
trying
to
to follow the law, Mr.
I understand. I understand. Okay, didn't we get a call for the question?
I am. I've
Great
called
taste.
for it a couple times.
All right, call for the question. That means that we'll take a roll call vote right now on whether or not we're going to stop discussion.
Second.
Holly?
So I'm sorry, what's
Now, this
what's
is to
the roll
stop
call vote for?
Stop discussion.
Stop discussion.
Or not passed. Call for the question has to be voted on.
Magistrate Jeffries,
Yes.
Magistrate Tice,
Yes.
Magistrate Likens,
Yes.
Magistrate Woosley,
No.
Magistrate Hounds,
Yes.
Magistrate Dye,
Yes.
Magistrate Hawkins,
Yes.
Magistrate Logston, Judge.
Yes? All right. We'll stop discussion. Now we'll take a vote on the resolution. And that'll be roll call as well.
Just to confirm, originally it was Jeffries and Tice that made the motion to pass this?
Pardon?
Yes.
Yes. Okay, that's what I have written down.
Was that a question or
You seconded the motion to approve the resolution.
And Judge, just so everybody, so it's on the record, it's for resolution 01062625.
Yes, sir.
Magistrate Tice,
Yes.
Magistrate Hounds,
Yes.
Magistrate Logston, Magistrate Jeffries,
Yes.
Magistrate Woosley,
No.
Magistrate Likens,
Yes.
Magistrate Dye, Magistrate Hawkins, Judge.
Yes. All right. Motion carries 8-1. All right, thank you. Now, if any
Take a break, Judge.
people are going, pardon?
Could we take a break?
I would, but here's what I'd like to have happen now with the agreement of the court. I'd like to go and just take a motion to pay our bills, then we'll take a 10-minute break and come back and go with the
Make a motion, we pay the
second
bills.
reading of the zoning map.
Second.
All right, we've got a motion and a second to pay the bills. All in favor, please say aye.
Aye.
Aye. All right. Motion for 10-minute break, please.
So moved.
All right, thank you.
Did Judge, did Mr. Rhodes leave?
Huh? Yes, he had.
right, let's go. I had to get in the ditch to people getting run over. Did the road shrink up after we built their house last?
A motion, we go back into session, please.
Second.
All in favor, please say aye.
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 Next item on today's agenda is we're going to, skip the thing about the health department budget presentation. Matt Rhodes had to leave, so that's all right. We're happy to go on now to our second reading of proposed zoning map amendment for Chateau Charisse. And I believe we'd like to have Anna Barge come forward and begin our discussion.
Good afternoon, Judge Vogel, Fiscal Court Magistrate, and County Attorney Baxter. Do I? Is this part of the public hearing or after the public hearing?
Well,
I mean, I don't mind being sworn.
Well, she's going to testify, Your Honor. I think she's going to give you a report, so she
all
probably
right.
needs to be sworn.
You swear to tell the truth, to say the entire truth, and nothing but the truth, all of you standing. So
I
help
do.
you God. All
I
right,
do.
thank you.
So this is for a zoning map amendment for Chateau Charisse. An application has been filed by Chateau Charisse for a zoning map amendment located at 2419 South Highway 53 in LaGrange. The property is 20.61 acres and is currently zoned C1 Local Business District with a proposed zoning of C4 Highway Service District. So this property and this zoning map amendment is a little bit unusual. So right now they don't have any businesses at the location, but they are trying to garner businesses, and because of the C1 zoning, they are unable to get the businesses at the site, so they are trying to go ahead and rezone so that they can attract businesses, and they will be able to speak more to that specifically when they have their turn to speak. So the existing zoning is C1 and the proposed zoning is C4. And as you can see, the existing land use and proposed land use will both be commercial, and the property size is 20.61 acres. And I think everyone's familiar with this Cherry House property that's just down the road from here on South Highway 53. So this is that property in question. And this is the zoning map. As you can see to the north, there is C3 zoning where this vet's office or dog kennel is, and then the Freddy's and Tractor Supply are over here. And then there's R2 zoning where the church is, and houses are over here with R4 zoning for Cherry Glen. So for the site history, there were 3 zoning map amendments approved on this parcel, with the final zoning map amendment to rezone the rest of the parcel in 1984. So they started out going through the process with industrial park district zoning, but after discussion with the residents nearby, they decided to do a less intensive zoning of C4, and they restarted the process for that in February with a neighborhood meeting, and they were recommended approval at Planning Commission in May. Now, there was not a June Planning Commission meeting, so the meeting minutes could not get approved until the July meeting, so we got them to the first reading on August 5th, and then all the notifications were done, which brings us to the second reading and public hearing today, August 19th. So like I said earlier, the applicant initially requested a zoning change from C1 Local Business District to IPD Industrial Park District. After receiving input from the neighborhood, the applicant amended their request for a zoning change from C1 to C4. According to Section 180.010 of the Oldham County Comprehensive Zoning Ordinance, the purpose of the C1 Highway Service District is to provide appropriate locations for general commercial businesses that require heavy infrastructure. The applicant states that some of the historic uses of the property were in alignment for C4 with C4 zoning. Keep in mind, as zoning rules change, zoning ordinances are updated, there's different uses that are allowed at different time periods. So those have changed over the years. There were two topics addressed during the neighborhood meetings as well as subsequent meetings with staff. One of those was commercial traffic on Sale Smith Road, which kind of runs a little bit adjacent to South 53, access through residential property adjacent to Chateau Cerise, and the unknown future use of the property. At the Planning Commission meeting in April, the case was tabled in order for the applicant to discuss future land use restrictions with some of the people not super close, but the people that live further out. The applicant then met with those surrounding property owners that live further out who attended the Planning Commission meeting on April 17th to discuss potentially excluded uses. This was included in your packet. This is just what's allowed right now. And then this is the C4. So both parties agreed to exclude the following uses. In our zoning ordinance, if I go back one slide, you'll see on the left column, there's permitted uses, and on the right column is conditional uses. Conditional uses are those that have to go to Board of Adjustments for a conditional use permit. So under the permitted uses category, they agreed to exclude adult entertainment establishments. Those would not be allowed anyway because of its proximity to a church across the street. And then under light industrial, manufactured home sales and service, you'll see there's quite a bit under conditional uses that they decided to exclude. So I marked those out in red right here so you can kind of get a visual idea of things that they agreed to exclude. So there's a lot of buildings on this property, so I wanted to give a quick overview of that. This is the showroom. Many people are aware of where the Cherry House showroom was. It's close to South Highway 53. And I put a little star in the corner so you can kind of see the location. This house is on, the red brick house is on the northwestern part of the property. And then the warehouse building is the large building in the rear. And then the barn is located centrally on the property. And then there's another house on the southwestern portion of the property. So in summary, the applicant, Chateau Cerise, is requesting approval of a zoning map amendment to change 20.61 acres from C1 Local Business District to C4 Highway Service District. We had these following binding elements, which were recommended for approval at the May 27th Planning Commission public hearing. These first three on this slide are very standard for zoning map amendments. Now, number 4 is this is where we get specific to the Chateau Cerise or Cherry House. To summarize, number 4 is basically if there's any major changes to traffic generation, size of buildings, parking, they have to come through the Planning and Development Office and Engineer's Office for review to make sure that they do not need to do any upgrades to infrastructure and then that they comply with any of our all of our current regulations. Next, in conjunction with this approval, the property owner will not allow commercial access to Zalesmith Road through the adjoining R2 property, also owned by the applicant. This was requested by the neighbors on Zalesmith Road, and the applicant agreed to that. So here is the nice version of the table that doesn't have the red lines. This is a summary. This is also in your packet that says the C4 Highway Service District property shall be limited to the following permitted and conditional uses. And that's just another slide with it on there. And then finally, hospitals and clinics for methadone addiction treatment or mental health psychiatric treatment shall not be allowed on this parcel. So that's all of the binding elements, and it concludes my presentation.
All right, thank you. Now, this is, we'll have a presentation by the applicant. All right, I mentioned.
Judge, I just want to make sure we're legal. We don't have a public hearing on the agenda today. Is that, I know that was posted in the paper. It's just not listed on the agenda. I just want to make sure that we're legal here.
This is a public hearing.
It's just not listed on the agenda as having a public hearing.
He's correct. I saw that earlier. I mean, we're still here if it's okay. But
do we need to amend the agenda again to add public hearing to this?
I don't know. Mr. Baxter?
Probably for the sake of clarity, Your Honor. So I assume Magistrate Woosley is making such a motion.
I will make the motion to amend this agenda again on line item B to include second reading of proposed zoning map amendment and public hearing for Chateau Cerise and the KOC.
I'll second.
All right, all in favor, please say aye.
Aye.
Just keeping it legal. That's all I want to do.
Aye.
thank you.
Didn't hear anything from the last 3 members on this. Aye? Did you all speak? I could. All right, sorry. Okay. All right. Proceed, please.
Okay, thank you very much, Judge Vogel and Honorable Magistrates. My name's Mike Gregory. I'm the attorney for Chateau Cerise, Inc. And before we get started, I have with me people who may not, or may not testify. I have Steve Whitehouse, who's one of the owners of Chateau Cerise, Steve Lannert, who is a commercial real estate broker who has listed the property and is trying to lease it for my client. And then we have Bob Vincent, who is our surveyor and engineer for this project in particular. They probably need to be sworn in, I would, just in case.
All right.
Right?
All like to stand. Raise your right hand, please. Pardon?
Attorney.
Oh, I don't think we ever swore in attorneys, do we? No, we don't swear in.
I'm okay. I'll do whatever makes you comfortable.
We just, you solemnly swear to tell the truth, the entire truth, and nothing but the truth. So help you God. Thank you. All right.
Thank you.
We just assume attorneys.
Levity noted. Yeah, it's a
We
good thing.
all attorneys tell the truth.
Yep. And also, we have at the back of the room the original owners of Cherry House, who then formed the Cherry House Inc., which then became Chateau Cerise. Owen Whitehouse Jr., who I know is Jeep.
Right,
I'm assuming you guys do also, and then Miss Shirley Whitehouse, and also Leslie Whitehouse, Steve's wife. Together, up until about a year ago, they ran the Cherry House for actually close to 55 years.
Yes, they did.
So,
I'll gratuitously add that I sleep in a bed my wife bought there 53 years ago.
well,
so.
you don't have to recuse yourself. I don't think it's okay if you continue to do that, unless there's something wrong with it.
No.
So I will do my best to be brief, but I also want to do justice to the subject matter. Ms. Barge explained the process that we went through to get here. We learned along the way. But the thing that I think is important, I've introduced folks to you who've been lifelong residents of Oldham County. And they're not seeking, and this is an unusual case, because they're not seeking to develop this property and change the zoning to develop it. What they're seeking to do is change the zoning to meet the uses to which it was put when they operated their business. How we got here is important for you guys to know, and it's something that I really actually didn't learn until I started digging into the matter. So what we're going to go through are the things that I think that you guys are going to be interested in meeting the requirements of KRS 100.213 for the zoning map amendment to find that either the existing zoning classification given to the property is inappropriate and that the proposed zoning classification is appropriate, or that there have been major changes of an economic, physical, or social nature within the area involved which were not anticipated in the adopted comprehensive plan and which has substantially altered the basic character of such area. We're going to address mostly the appropriateness of the zoning in this little exercise. So, Ms. Barge pointed out that there have been three, and I need to make sure I get all this up. She went through the aerials. I'll do this again very quickly, and then I'll go through the zoning changes that occurred. The Cherry House business began operating in 1969, so it was right at the time that zoning was adopted in Oldham County. And Mr. and Ms. Whitehouse recognized at some point after they got the furniture store up and going that they needed more space, and then they thought it should be commercial. So this is the property as it exists now, a little bit different look from what Ms. Barge showed you. And let's see if I can operate this. This aerial, if you can see, so we have the Cherry House here. This property, where I have the cursor over, this property, and this property all belong to the Whitehouse family. One of the properties is actually in the Chateau Cerise name, but it's not at all involved in our rezoning effort here. So all of these properties that they actually live on are zoned R2, and probably will be for the foreseeable future, certainly my lifetime. And we are not seeking to rezone that. And I think that was an appropriate move on our part. We learned our lesson, but Zale Smith Road is not a road that can accommodate commercial traffic, and we're fine with that. So, and also Ms. Barge mentioned that we have agreed that there will be no commercial access to Zale Smith Road from the property we're seeking to rezone, and it would have to go through our properties anyway to do that. So that's not going to occur. And then, just to be clear, we have filed this development plan as part of this project. It's, these are not proposed buildings, these are existing buildings. So nothing is going to change on this property, certainly for the time being. The intent is to lease the buildings out that are on the property. One of them, this big one in the middle, is a warehouse. Its footprint is about an acre, but it actually has about 55,000 square feet of usable space. That's one of the issues as far as the zoning is concerned that we're here to address today. So the very first zoning change, and this is, by the way, this is I just have a copy of the zoning ordinance, the originally approved in 1974. I do not have the original from 1974. So this one, it was last revised in July of 1983. So it encompasses the last two zoning changes that Chateau Cerise sought. And inside that ordinance, we have C1 local business district zoning, same name, the same title that it kept today. But if you look in the permitted uses and the conditional uses, furniture store does not appear. So we had a furniture store that was granted C1 zoning in 1969, originally an acre, and it did not fit in C1 zoning. The first zoning that you could find it in is C2. We don't know why C1 zoning was sought or assigned at that time. It's a long time ago, but that's where we ended up. And so I have the minutes from the Planning Commission meeting in 1979, where this is, I've highlighted the docket, and there's a discussion that this was one of the first zoning changes that was sought in Oldham County right after the ordinance was adopted. And then there's a discussion that this is an expansion of the existing C1 zoning. Normally, an expansion would not occur if the zoning was inappropriate to begin with. Again, we're not complaining. We operated our business this way. And we don't know why it was done, but what we're trying to do today is basically correct these things that started decades ago. One of the interesting things in here is the finding that after the completion of I-71, the Cherry House business, which was started as a community-type business, which if you just went by the title would be C2 zoning, became a nationally known enterprise as the business increased far beyond what was anticipated by the comprehensive plan. So that's a finding that would be necessary for a zoning change. And again, no issue with that, but it's interesting that in 1979, this business had already expanded to nationally known. And then the final zoning, the map amendment, where we expanded to the 20 acres, occurred in 1984. And again, we have the highlights. Mr. Whitehouse, who's in the room with us today, explained that he had no idea when he started the business 16 years before that it was going to grow like it did. By this time, it had 8 buildings, and it had grown 35% over the year prior. So my demonstration on all this is just to show this business from early on did not fit in the zoning class that it has. And I don't think anybody here who knows the Cherry House business would complain about that. It was conducted in the way that, frankly, we're all proud of in Oldham County. Many of you are business owners, folks that I know, and I understand what it means when you have, standards that people observe in the community and in their business. And that's the way this business was conducted until they finally had to call it quits last year. So what I would like to do is have Steve Whitehouse explain more of the history of how the Cherry House operated. And then when he gets done, I'll walk through the C4 zoning and why we think that's the appropriate zoning for this property.
Hello. I've had 2 more hours to get more nervous about standing up here in front of you all. I'll try to get through this without too much problem. So first of all, Judge, Magistrates, I appreciate you all taking the time to hear us out. I know you all are familiar, some of you are familiar with the history of the Cherry House and the property, but I think a little description will be useful for the decision that we are asking you all to make. When my mom purchased the store, and I'll get into that in a minute, they took a second mortgage out on their house to start the business or to continue the business. And my father built them a little showroom out on the property on 53. At the time, 71 was not open. 71 opened shortly thereafter. And as Mike said, my parents thought they were opening a little community business. Never in their wildest dreams did they believe it would turn into an internationally known business. They originally purchased the property from Miss Anna Crum, who owned most of the property from Zellsmith down to the Kinzer farm, for my parents to have a home and a part-time farm. My father was in construction. He built the barn, then they built the brick house. And during that time, my mom bought the furniture store from Phyllis Cash, who was the wife of the developer of Green Valley. I'm sorry to bring that up again. When my mom purchased the business, Miss Cash had been operating it downtown LaGrange from a storefront. So we moved into the showroom that my father had built, and this is the short history. The barn became a warehouse. The barn and the showroom were enlarged. The barn was converted to a showroom. A separate warehouse was built. That warehouse was torn down. A bigger warehouse was built. When I came home from college, my parents and I built a house for me to live on the opposite side of the property. That's one of the houses that is being rezoned. They and my wife and I built houses on the opposite side of the lake on the current R2 property. Then both of those former houses were converted into showrooms. A new and bigger warehouse was built then, or the warehouse was enlarged. In fact, the size was doubled. We were unloading a semi-trailer in there the day we put the roof on the warehouse. By 2000, the business had grown to 4 locations: LaGrange, Shelbyville, and 2 separate locations in Louisville. We had 100 employees, $12 million in sales, and we were shipping furniture all over the U.S. and internationally to several countries. All of that was serviced out of the warehouse on the property. The LaGrange showroom itself generated approximately 1,000 car trips, and on certain days, buses. And we were averaging about 20 semi-deliveries a week and about 20 delivery truck trips off the property a week. And we were feeding a lot of customers to local businesses, especially the restaurants. But in 2000, furniture production started moving overseas, and the business changed dramatically. Our business had to undergo some major changes, and from then on, it was an issue of if we could keep up with the constant changes we had to make to keep up to survive. We had a massive surge in business during COVID, but that surge became a trickle in the following years. And we realized that the way business was conducted had changed so much in the months during and after COVID that my wife, Leslie, and I saw that the business would require some massive changes if we were going to survive. And we were in our 60s. We didn't feel like we had the emotional energy to see through an uncertain future. The level of change that we were facing would have risked the entire business and probably our ability to retire. The part of the decision to close on our terms was the knowledge we had buildings, and we could rent those buildings and have the income to replace what we had from the furniture store. And we found out there was a problem with that, and that's why we're here today. We've had advisors tell us that selling would be the prudent way to go, to put the $30,000 in yearly property taxes, the $96,000 in yearly insurance premiums, the $2,500 a month utility bills, and all the deferred maintenance on somebody else's back. We heard concerns among some of the folks who live in the area that changing the zoning could open a Pandora's box if the property were to be sold. And there lies the dilemma. This is our home. We live behind the commercial property. We've invested a lot of time and treasure to make it attractive. We drive through it every day going to and from our homes. And we don't have any plans to move. Because of this, we care about what types of businesses locate on the property. We want to be selective. We've turned down a CBD dispensary. It was a legal use, but we didn't feel it was compatible with what we wanted to achieve. We had somebody wanting to store heavy equipment outdoors. Again, an allowable use, but it wasn't compatible with our vision. We want to be able to attract tenants who will use the existing buildings and parking in ways that are similar to the Cherry House usage, especially for the two buildings that are warehouses. That's why we're asking to move to C4. We have found the current zoning restrictive, something we never imagined in the scope of our business that operated from this site for 55 years. We've had to pass on a furniture store, an indoor contractor storage, a community theater because they were not allowable uses in our current zoning. And they were not willing to wait and see if we could get that where that would be allowed. And I'd like to take a moment to address traffic. Even at the height of our business, we never had any state or county officials contact us with traffic concerns. We didn't have any complaints from neighbors. I've spent many hours trying to think of other businesses that could occupy those buildings that would generate more traffic than we did. And I keep coming to the same conclusion. Any business that would generate more traffic is going to require extensive changes to the buildings and the parking, and therefore would require us to go back before planning and zoning, which we understand will have to be done. We have no plans to change the footprints of the building right now or the parking. It's our intention to rent the buildings as they sit with only the internal renovations needed for a tenant. I grew up in this business. I was 9 when my mom started the store. Leslie and I and my parents before us were deeply involved in the day-to-day running of the business. We had to go out and direct traffic some days coming in to park people. We were parking people in the fields. I'm intimately familiar with all facets of the business that we created, including the car, bus, truck, and customer counts. I believe it's a very low chance of any combination of businesses creating more traffic than Cherry House did historically. So I asked the court to approve our application for C4 zoning, which would allow us to create what is essentially a small business park that our neighbors in the community can be proud of. Thank you all very much.
All right, thank you, Steve.
Thank you, Steve. So you understand the scope of the business from what Steve said, which is important because we're asking obviously for an increase in zoning capacity from the C1 to C4, which is, it's not a huge leap, but it is a leap. So what we did at the Planning Commission, Chairman King initiated a pretty interesting discussion analyzing the different buildings on the property and what zoning would be required for those buildings. And again, the building that came up with to be the problem was the 55,000 square foot warehouse, which would require at least C3 zoning. What Steve described in the way of the business that the Cherry House conducted was, especially with the trucks coming in and out, the storage, the assembly of furniture in the warehouse, and the delivery services. After we looked at the current code, the current zoning ordinance, we felt like that there was one use that was not covered in C3 that most described what the Cherry House did. And so I did a side-by-side comparison of C3 and C4 zoning for you. There's really two differences. The C3 is a general business district, and I'll show you in a minute the map that, so you can see how the C3 lies in that corridor. But C3 would allow, retail and personal service establishments with a gross area less than 100,000 square feet. We're fine with that. But the thing that, when we get to conditional uses, is the point where the trucking type business that was conducted by the Cherry House and that might utilize that warehouse is in the carting and express hauling establishments. As far as defining that, and one of the planning commission members asked, how we would define that, our vision of it is and the Cherry House was like this. It's kind of a fulfillment business. You bring in product, and then you ship out product when people order it. And in the Cherry House realm, originally they would bring furniture in, some of it maybe based on special order, and then ship it out to customers, or they would come pick it up. In later days, furniture would come in from China or wherever on shipping containers, and they would assemble it at the Cherry House and then ship it out to customers. Either way, it's kind of a fulfillment business that they were conducting. And that's why we feel like, and this is a conditional use, so it's not even a straight permitted use in the zoning. It's tantamount to having C3 zoning, and if a business wanted to conduct this type of use, it would still have to go before the Board of Adjustments and Appeals here in the county and meet the conditions. We want that ability, but it's also not a given if this zoning is granted. We just feel like that's the most appropriate zoning for the business because that's what we did before. And that's what the warehouse is basically constructed to utilize. The other buildings wouldn't accommodate that kind of use anyway. So, they're not irrelevant, but this is the main point on why we think this is the appropriate zoning and why the prior zoning is not appropriate. And then, just to show you, and Ms. Barge showed you a little bit more close-up of this, so that let me orient myself on my own map. Where am I, Steve?
The green is 71 corridor.
Oh.
So you want to come down right
Here we
there.
are.
Yeah.
You'd think I'd know this by now. So this is the Cherry House property, the Chateau Cerise property. We're abutted by C3, just to the north, sort of the north. And then right across the street, as Ms. Barge pointed out, is more C3. And then a whole bunch more C3 all the way up to I-71. And then there's some C4 right at the 71 corridor. The things that are located on that are the things that we would consider to be more closer to the kind of business, not exactly, but closer to the kind of business the Cherry House or the Chateau Cerise would intend to lease to, would be more like the feeder supply, which is in C4. The Walgreens is in C4. And, those are businesses that are fine for that, but that's, comparable C4 property on that side. So we feel like that zoning, the C4, basically fits within the area as well, that we're not going to be changing the nature of the area if we, especially based on the business that was done by the Cherry House before that. We're just not going to be really affecting the area with that change. And so, not to beat a dead horse, we feel, and again, this is a different case. We don't have a big development plan. We're not going to be putting up a bunch of new buildings. We're not going to be introducing, we do have unknowns because we don't know who's going to occupy the buildings, who we're going to lease them to. That's a concern. We understand that. It's a concern for the people, for the White Houses who live on the property behind Chateau Cerise as well. But we have folks who, are lifelong Oldham County residents, have Oldham County standards and mores at heart. And what we're asking to do is to be able to continue to use our property in similar ways for the future. Thank you very much.
All right, thank you. Is there anybody here who would like to speak in opposition to this request? Okay. And do you state your name and address?
Karen Rose Hunstiger, 1616 Crestview Drive, LaGrange.
Okay, did you stand when we swore everybody in?
I did stand when you swore in your county people, but I will swear again, sir.
You swear to tell the truth, the entire truth, and nothing but the truth, so help you God.
I do. I just want to remind you that once we change this, Highway 53 has not been enlarged. The left-hand turn lanes, and I realized when Cherry House was in full swing that they had a lot of traffic. But we have a lot more people living in our area. A lot more people are moving in off Zale Smith and the area down 53. And so traffic is way higher than it's been in the past. And this change will add more traffic. Thank you.
All right, thank you. Is there anyone else who would like to speak in opposition to the request? All right. Are there any concluding statements you'd like to make at this point? Or you
guess
can
I have
really-
to. Oh.
I think you sort of spoke to rebutting the traffic issue, but you might
Yes.
like to speak to that.
Again, that's a concern that we addressed at the neighborhood meetings, and as well we've addressed with the planning staff. We feel like that the binding element on, which I can pull that up, I think. The proposed binding element on traffic, which is number 4, we'll address that if and when the time comes. And the other thing I would say about traffic, and it's true. There is more development. There's going to be more traffic on the Highway 53 corridor. That the Ernie Harris Parkway, the PUD, that empties out onto 53, 0.8 of a mile from the Cherry House property or the Chateau Cerise property, is going to continue to develop. There's going to continue to be more traffic going both ways off of that road too. It's something that certainly all of the county infrastructure folks are going to have to be aware of, and we all are going to have to work together to manage. But to Steve's point earlier, what we're going to be doing on this property today, we do not feel like is going to increase the traffic any more than it was at the time the Cherry House was operating. Thank you very much. Sorry for belaboring the point.
Okay. All right, Ryan Fisher.
Thank you, Judge. I just want to say something real fast before we get too far down the road, and maybe the county attorney can weigh in on this. So it's been brought to my attention that French is not myself and Anna's strong suit. She's currently studying German. I've got a 41 on Duolingo for Spanish. So Chateau Cerise is French for Cherry House, which I learned at the Planning Commission hearing. So Cerise is spelled C-E-R-I-S-E. In the ordinance, Anna spelled it C-H-E-R-I-S-E. So I'm pretty sure that's just a minor change.
Yes.
But I just wanted to bring that up before we got too far down the road. So that's all I needed.
All right, I do believe that we can, anybody else to speak? We can close the public hearing and go to the magistrates now. Magistrate Jeffries.
Is motion in order at this point?
Yes.
Okay, I would like to move that we accept their zoning map amendment request along with the 7 binding elements that the Planning Commission forwarded to us for consideration. And this is on KOC 25-920-511, change of zoning from C1 to C4. And I'd like to move that.
All right, we've got a motion and a second.
Second.
All right, a discussion by any magistrates? Magistrate Woolsey?
I just want to make sure everybody understands this. My grandmother and Jeep Whitehouse are, I think, second cousins. I met Jeep probably when I was a teenager, but haven't seen him since. I don't think there's an issue today, but I don't plan on abstaining unless I'm told I need to. But it's been many, many years since I've seen him, but he is technically related to me down the road.
I see no reason for you to have to abstain.
Thank you. All right.
Magistrate Hawkins.
Is it an appropriate time to address the applicant with questions?
Yes.
Okay. Two questions. Did you mention earlier that everything around on that side of the street was zoned C4? Because I'm looking at the map.
No, ma'am, it's
Okay.
not. And I'll bring up the map that I was looking at. We have C3 abutting the property now.
And then
The
R.
C4, yeah, the C4 does not, there's no C4 until you get to the, here we go. Yeah, there's no C4 until you get up to here. The Tractor Supply, which is essentially right across the street, this little tract, and then all of the commercial development that
Right, okay.
goes, that's all C3.
That's what I was looking at.
So this
too.
would be, our C4 would be the first or only C4 in that general area up until you get, it's 0.8 of a mile to the interstate, by the way.
And then right next to, right there,
That's right.
Cherry Glen Drive, that's all
This is
zoned R4.
Yes, ma'am.
Okay.
Yes, ma'am.
So it's residential.
And this is R2. All of this is R2.
So it's surrounded by residential. Okay, on C4, on that C1 right there that you're proposing is changed to C4, yeah, right there.
Yes, ma'am.
How many buildings are on that piece of property?
There are 5 buildings, or are there 6 total? There's okay, well, there's 5 buildings. They count 4 for use because one, they
Okay.
just store maintenance equipment in.
So a concern that I have is without a building plan, if we approve a zoning change without a building plan, then moving forward, while it may not be able to have like adult entertainment, things like that you've struck out, the buildings could expand. They could get to be the height that's allowed in C4. It could expand without necessarily having to come back for a zoning change. So it could potentially, right next to that neighborhood there, be a warehouse, say for Amazon or something like that, and it could expand beyond would you say 55,000 or so square feet that it currently is?
Yes.
And I know that they would be alerted to that, but there would already be a precedent of C4 on that strip on that side, and then B, a zoning change without a plan. And then I'll segue into when Christian Brothers presented, not too very far from here, there was a statement made by a magistrate to deny that application to change to C4 because there wasn't another C4 and that would set a precedent. So I'm kind of in that camp as well of not changing this to a C4 because I don't really want to set a precedent for those neighbors around there. And as I was kind of looking into this as well, they can continue to, within our zoning restrictions, operate under what I understand to be a non-conformance because it doesn't expire. And so they could continue doing as they're doing because they've been doing it so long and haven't had complaints and however that works without any zoning change having to be sought.
Are you referring to KRS 100-253?
Yes, subsection 3.
Yeah.
Mhm.
So Mr. Baxter raised that at the Planning Commission hearing. My issue with that is I don't think we had an illegal use to start
Right.
with.
Right.
Which is why I went through the former Planning Commission, and then ultimately Fiscal Court would have approved the zoning map amendments that we already have. So I don't necessarily think that statute applies. I'm not trying to cut us out of an option, but I think that that's an arguable thing. Now, as far as you are correct. If there were going to be changes to the property, to the footprint of the buildings, tearing buildings down, those sorts of things, we would not need a zoning change to do that. Those things would all go through the planning staff at that point, and those would have to meet the requirements. So I understand that's a concern that people have voiced for the future. Once you make the change, it doesn't go back.
And then there wouldn't be
we
any.
do have a plan. I mean, the one thing that, and I know it's uncomfortable because we didn't come in with a plan to create a development with a known use. We have an existing development, and we have a plan that, in my opinion, and we addressed this at the Planning Commission, meets all of the requirements for a plan under the subdivision regulations. And I think the Planning Commission felt that was true, and that's why they made the recommendation today.
And I'd like to just remind the court too that when you change to a C4, C4 is called Highway Serviced District. So I believe that the intention, especially with the comp plan, and where we've projected maybe C4 would be in the future, would be along that highway district because it's a highway district. And so I would just like to remind the court that 53 is not I-71. So therefore, I don't think it's in line with our comp plan to change it. So that's all I have.
Okay.
Magistrate Jeffries.
Just to point out to Magistrate Hawkins, if we accept this proposed zoning change, number 2 of the binding element states there shall be no changes to the plan without review by the Oldham County Planning Commission and the engineer's office. So I think that would address part of your concern.
And when you look at the neighbors right next door, they would not have any recourse for, say, like we were recently talking about the data centers, there would be no recourse for them to vote out somebody that they disagreed with. They would only have to take it up with the Planning Commission, who are appointed. They're not elected. So there's not as much at stake when the neighbors come and speak to the Planning Commission versus when they, could vote out somebody in our position who is like the buck stops here, but we wouldn't be able to see those plans. It would already be changed to C4. So those plans would not come in front of us. So they could do some of the things that they wanted to do in the C4 while yet abutting an R2 residential all around that. So it's just a concern of mine.
Yeah, I understand, and that part's true. And for the time that of course, the R4 is what's directly next door. The R2 that's immediately behind the property at the moment is owned by the White Houses and for the foreseeable future. So what you're expressing is certainly a potential future concern. I'm not going to try to negate that. But the only thing I could say about as far as the R4 property, interestingly, none of those neighbors have shown up to the neighborhood meetings or expressed any complaint.
I don't think they were necessarily notified either, right?
All of them that were within 500 feet of the property were
yeah.
notified. They were, yeah.
Manager Woosley.
There is a fairly large lake that runs primarily on 2010 Zale Smith, but also butts up to the property that's the large track for Cherry House. What's the plan there to protect that lake, or do you have any plans there at all?
That lake, again, if we don't make any changes to the property, nothing is going to change with that lake. It already handles all that. In fact, that lake is a filter for the subdivision next door that's in the R4 that has silt draining down fairly constantly.
Can you go to
Which has
aerial
been,
two?
that was a big complaint.
Can you go to aerial 2, and will that show us the lake up there?
It will,
Yeah.
yes, sir. There's actually about 6 acres of lake that are on this property. So this is the big lake, and then there's a smaller one here, and then even, kind of a smaller one here.
And you currently are not in the city limits, but is there plans to, at some point, bring this property into the city limits?
Well, that's a really good question. If, so as far as development of this property is concerned, the way the Cherry House operated, it fit within the existing infrastructure, including the sewage, right? The only way that you could do a whole lot more on it would be to, access the sewers through the city of LaGrange. They don't have any plans to do that currently, in part because they don't want to pay the taxes that are associated with it. I mean, I hate to say that, but that's really kind of where they are at the moment. But it's a possibility in the future if they really wanted to, or if someone else, if the property were ever sold, that's what they would have to do to try to access the sewers. Sorry about that. I covered that up.
Anyone
The only
else?
thing you're requesting, C4, and the only thing you're requesting the C4, is that on the main Cherry House property?
That's it, right here.
There was one
Yes, sir.
piece that you were doing an R something, wasn't it, or was it a?
Well, the initial thought was to try to move, and actually to try to move to an industrial park district, but also include all of these properties in that. And we found out quickly that was just a bad idea. And so we changed, and, thought about it, did the analysis, and I feel like I keep beating a dead horse, but every time we look at what the Cherry House did and we, look at the, especially the warehouse use, which was a big part of the Cherry House business,
Sure.
we kept coming to C4, and that's why we decided to go that route, to ask for it.
Anyone else?
Judge, would you be willing for a motion?
We have a motion.
We've got a motion on the floor, and we're just taking more comments, and I personally don't have any problem with this. Steve, are you and Leslie going to stay there a long time? Right, well, as long as, my only concern would be, with you all there, I have no concern. I just, but no one can predict exactly what any successor owner might do there, So that's, but Mr. Ladders, do you have any ideas about what would fit right now to share?
The whole purpose of asking for C4 zoning was to accommodate the two buildings that have truck docks that are considered warehouses. These buildings are unleasable unless it has a C4 zoning. And so what we're trying to do is not change the zoning, but bring the zoning in compliance with the uses that have been there for the last 50 years.
Yeah.
Does that answer the question?
Yeah, I guess so.
Thank you, sir.
I have a question for him.
Yes,
So you've got the property up for sale, right?
No,
Oh, I
for
thought it
lease,
was.
not for sale.
Lease, okay.
That's just for lease, and but not for sale.
all right. Heard the term Amazon warehouse mentioned. I've heard it mentioned negatively in other circumstances. I don't know what's wrong with an Amazon warehouse. I'd love to see one here. That's too. I know that's far too small for an
I shouldn't have
Amazon
said it.
warehouse.
The building's a little small for
Right,
Amazon, but
right.
I was using that as a
Yeah.
as a comparison as to what might be.
I understand that. No, but I don't. It's, okay. I think we've got. Let's go for the motion. We got a motion and a second. You want to call roll call vote, please?
What was the motion? Can we get that repeated?
Motion that this ordinance change the zoning map, rezoning on 20.34 acres of land located at 2419 South Highway 53 LaGrange from C1 Local Business District to C4 Highway Service District zoning classification.
And there's attached the 7
And
binding elements.
with the
That's what I wanted to make sure we had the binding elements attached.
Judge, can I ask Magistrate Jeffries a question? Do you incorporate the testimony that was presented today as the factual basis for your motion?
Yes, sir. I would.
With that amendment, Judge, if somebody will whoever seconded it will second that, then I think we have an adequate motion.
Hawkins?
I'm sorry, I was listening to you, but would you explain it?
I just asked him if he is incorporating by reference the factual testimony that was presented today in support of his motion.
And I should have done that, knowing as a former chairman of the planning commission, I should have known that, but yes, sir, I would agree with that.
For it.
What about the name change? Do we need to include that?
Name
Need to
change?
include anything about the change of the name?
I just think that typo needs to be corrected in the ordinance.
I'd like to, being I don't mind, so yes, I agree to the name change and agree to the testimony being factual as part of the, what am I adding it to as part of the motion? Yes, sir, okay. recently, and I don't even know if this is legal to do, but I guess it is, Mr. Baxter. It's okay that we strike out all of these conditional uses for a C4 as it was presented by the Planning Commission. It was, they brought it forward to us as, for example, zoos was struck. It's legal for us to strike those conditional uses out of a permitted use or conditional use on a C4. Is that right? It's legal?
Yes, we had a long discussion about this at the
Okay.
Planning Commission, but yes, it is legal.
Okay, I wonder if we could add in, just because of recent events, if we could also strike out under utilities, Magistrate Jeffries, private utility buildings and facilities, and then under that is also under utilities, sewage treatment plants. I wonder if it would be okay to perhaps strike those as the motion maker.
No, I wouldn't agree to that.
Okay, I still agree to the first two.
All right, we have a motion and a second with the incorporated restrictions and the binding elements and incorporated logic presented here today, the truthful statements as part of the testimony. So, Holly, will you please call the roll?
Magistrate Likens,
As long as it's not going to be a data center, I'll say yes.
Magistrate Tice,
Yes.
Magistrate Woosley,
Yes.
Magistrate Jeffries,
Yes.
Magistrate Hounds,
Yes.
Magistrate Hawkins,
No.
Magistrate Dye,
Yes.
Magistrate Logston,
I'm sorry. I just thought you couldn't hear.
Mike's not on, Mike.
Judge Vogel.
Yes. Motion carries 7 to 2.
Judge, may I make a statement? I just wanted to say that it's nothing personal, and I love and respect Cherry House and the history.
With me also, I was going to vote yes for it, but I'm really worried about C4 zoning right now, and what it could be used for, so.
Okay, thank you. Appreciate your patience. Had,
Thanks very much to you guys for your patience. I know it's been a long day.
That's been, right, it's not over yet, actually.
What was that?
For us.
Oh, yeah.
Okay. Committee reports a recommendation, opioid funds for drug take-back program. That's under C here. I think Mike Meese took off, but I think what we're asking here for the committee of the whole to
Mr. Whitehouse.
all right.
You know, y'all been talking about a dream that my wife and I bought. We started that 50 years ago. Had no idea. She started this, it just took off. Before the World Trade Center collapsed, we had 70 employees and 5 delivery trucks. We delivered all over the East Coast. I put furniture in condos in Detroit, Chicago, all over. We sent containers to Miami that went to St. Thomas. We were blessed. And every time we needed a building, we built it. You know, with the little knowledge you get in problems, I knew how to build. So we'd build. And we built, and we built, and you see what happened.
Right.
What a blessing.
Right.
God, he was with us all the way.
Right.
Or we would have never made it.
Well, Cherry House put
Thank y'all.
Cherry House put LaGrange on the map 50 years ago and subsequently. All right. Yeah, thank you. Right. That's all right. Leslie sold me the chair I'm sitting in my office, so.
Thank y'all.
All right. All right, Jeep. Good job. Good job, Jeep. Thank you. Okay, the next thing here,
Stephanie.
Court's still in session. That's all right. Thank you, Mike. Okay, good luck. The next thing here, the Sheriff's Department has asked for some support from our opioid abatement funds, and they have some advertising coming up, and they're asking for, I guess, $935 so they can put an ad in the Era prior to their next drug take-back event. And they also want to buy, they gave these out, these packets, at the last drug take-back. What people do is pull them open, drop drugs in them, put water in here, and then they are resealable, and they shake them all up, and it dissolves all the pills. So we didn't have an opioid abatement meeting this month, but I thought it'd be all right to ask everybody for $935 today to let them go forward for the. We got $484 for additional funds for these packages here, and $935 for one full page ad in the Era, for a total of $1,419. And this would come from our opioid abatement funds. And then we're going to come back in September, and the opioid committee will be able to take a look at the balance of the year. But our next drug take-back is coming up here very shortly.
Judge, I'd like to make a motion that we approve the spend of $1,419 to include the purchase of more doTERRA packets, as well as a full-page ad with the Oldham Era to come out of the Oldham County opioid abatement funds.
All right.
Second.
All right. Any discussion on this? All in favor, please say aye.
Aye.
Aye. Motion carries. Thank you.
1419.
1419. Okay.
Might be.
All right. Thank you. The litter abatement grant, Becky Zockline, there's something to report on that.
Thank you, Judge and members of the Fiscal Court. I come before you to ask you to sign or give the judge permission to sign the annual litter abatement grant. This brings about $80,000 into the county to help reduce the amount of litter on our roadsides. We use volunteers and pay these volunteers of nonprofit groups pretty handsomely to keep our roadsides clean. And I think our roads have been pretty clean. They're doing a great job. So,
Make that motion, Judge.
Second.
All right. Any discussion on this? Mike?
Judge, I'm going to have to excuse myself from voting on this. Great program. Thank you for doing it. But I'm with the Rotary, and we pick up trash and off the side of the road, so I don't think it's fair for me to vote for this.
Okay. Mr. Hawkins?
I also do for nonprofits, but I vote. Should I have abstained? Should I abstain?
You're getting a
Money's not-
benefit of the grant? You're
Oh, no, I
nonprofit-
just do it
you're-
because it's fun. And it cleans up my district, and it helps a nonprofit.
Are you picking up trash and getting paid for it? Is getting money from this grant's the question?
I'm not, no.
But the organization you're working with does?
I'm not working with them. I just pick up trash on occasion on a Saturday.
Well, if you're not directly benefiting, no, you don't need to abstain.
Okay. It's specifically the animal ones that go out, and I'm not trying to adopt a new dog. It's just fun for me.
I mean, you're picking up roadkill on Saturdays?
It's not roadkill. It's like Becky gives us like sticks and bags and orange vests, and it's hot, and you go out there and you chit chat with people and pick up trash, and a lot of liquor bottles. We pick up a lot of. Yeah. Anyway, but I've never abstained. I've never felt like I should abstain from this, so I won't today. Anyway.
All right, we've got a motion second on the floor. All in favor of this grant, please say aye.
Aye.
Aye. Okay, thank you.
Thank you.
All right, we appreciate that. We're going to jump ahead now to the personnel actions, Tina Schaaf. And we're going to do both these. We requested earlier, do both our closed sessions all at once, but let's get everything else off the docket.
That would be great.
We have some personnel actions this afternoon. We have planning and zoning. We need, planning and development, we need some part-time help down there for about 90 days or so. So we would like to hire Scott Thompson as an electrical inspector for $30 an hour effective on the 25th. And that's going to be for about 90 days.
Judge, I'll make the motion that we hire Scott Thompson for up to 90 days at $30 an hour.
All right. Is there a second?
Second.
Second. All
30.
right.
It says it's
All in
30
favor,
now.
please say aye.
Aye.
Aye. Our motion carries. Next.
30. The second thing we have is, you all know that Becky is leaving at the end of October, so we would like to get ahead of the FEMA mitigation grant admin part of that job. So we have Cindy Harbin that's agreed to come on board to help us through that. She's familiar with the process. Most of you know her from the Code Enforcement Board. She's been on that board for 23 years. I believe she's going to step down from that position while she's taking this one. But we would like to bring her on and get her going with the grant administration part of that job, and that is for 90 days as well, $30 an hour, not to exceed 20 hours per week, and we would like her to start on that on the 25th as well.
Judge, I'll make the motion that we hire Cindy.
I'll second that.
All right. All in favor, please say aye.
Aye.
Motion carries. Thank you.
Right, and the last one is a promotion at the police department. We would like to promote Sergeant Stephen Jenkins to the admin major position at $120,000, $99.20 base annual salary, and that's going to be effective tomorrow, the 20th.
All right. I'll make that recommendation.
Second.
Second. All right. Any discussion? All in favor, please say aye.
Aye.
Aye. Anyone opposed? Motion carries. Thank you.
All right, thank
All
you.
I have one appointment to make here to the Planning Commission. Sam Finney is leaving the commission at the end of this month, and I'm recommending to replace Sam, Deborah Graham. I know a number of you know Deborah. She all comes from the Goshen area, and Sam is not exactly Goshen, but he's Covered Bridge Road, I believe. So there's a close area. So when Deborah is a fine individual, I think she'll do a great job there. So
I'll second that.
all right. So any discussion? All in favor, please say aye.
Aye.
Motion carries. Thank you. All right. Now I'd like to ask that the courts go into executive session for two items. One is the pursuant to KRS 61.810 subsection C, discussions of pending litigation on behalf of a public agency related to the Purdue Pharma personnel actions, and not just Purdue Pharma, and that would actually impact item F on the agenda for today. And then also in closed session pursuant to 61.810 subsection B, regarding deliberations on the future acquisition or sale of real property by a public agency. So, there a motion that we go into executive?
I second.
Yes, okay.
Do we need to outline who's going to be in the meeting?
And that'll be Kevin Nuss and Holly. All in favor, please say aye.
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 All right, motion carries.
I need a nap. I've been waking up at 3 o'clock almost every morning.
Larry, we good? Good?
All right, we go back into session, please. Is there a motion?
So moved.
Second.
All in favor, please say aye.
Aye.
All right. Regarding the executive sessions that we just completed, in regarded to the second one, KRS 61.810, deliberations on future acquisition or sale of property by a public agency, no action was taken. And on the other one about a closed session regarding the discussion of pending litigation on behalf of a public agency, I would like to make a recommendation that we proceed and to join the Purdue Pharmacy bankruptcy lawsuit. I'll make that motion.
Second. Judge, hold on. Just to be clear, we are approving we are voting in favor of approving the bankruptcy settlement in the Purdue Pharma bankruptcy, is what the documentation we had was.
Okay.
So,
We're going to vote to approve the settlement.
yes, sir.
All right. I'll make that motion. Was there a second, somebody?
I seconded it.
All right. All in favor, please say aye.
Aye.
Motion carries. Thank you. Now we're at the second public comment here. Or is there anybody here who would like to address the court at this point? Okay. All right. Well, seeing no one, we'll go on to close the meeting. Magistrate Logston, any final comments?
Went down Rollington Road the other day. Project's looking good. Hopefully it'll be done within the 2 months that they're looking forward, and we can open it up, get the school buses and everything through. So it looks like it's on track.
All right. Magistrate Dye.
Thank you, Judge. School started. Be careful around the buses.
All right, thank you. Magistrate Hawkins.
I'll second the sentiment about school is in session, so please be careful. And then also 393 just was repaved, so I'm just asking for patience. We're still restriping that. And then I've also requested, as you come off of Centerfield Drive and over there by Echo Valley and Briar Ridge, that the striping that comes off of that has additional beads in it. Over there by Centerfield, it was already done, but as we move forward, I am requesting that gets added to add a little bit more reflection, specifically at night, and this is to mitigate having to use lights to light the way. But I understand it is kind of dark, especially if you have a hard time seeing at night. So just want to say I'm working on that, and to please be patient, because I know it's a lot to be able to navigate when the stripes aren't fully in place yet. So that's all I have today, Judge.
Magistrate Logston, did you have?
Add one more thing. Please, in order to, with our commitment we made to Organ Creek Farms, that we would put together a committee as soon as we can to get that project moving forward.
Okay. Magistrate Hounds.
Yes, thank you, Judge. Depending on where you live, you get rain. It's the weirdest thing. Tuesday night, Magistrate Jeffries, I don't know how much you got in your rain gauge, but I think I was over 5 inches. It came down fast. There were lightning strikes to residences. There was at least one water rescue and a couple of collisions. If you have data from that event, if you can send it to my email address, chounds@oldhamcountyky.gov. We're trying to compile some of this information we can give to the engineers that are working on a project in that area. Some pictures that I've gotten are dark, but you can still see the amount of water that was running across the road. To that point, if you come across a roadway that there is water running across it, the saying is turn around, don't drown. What happens is when people go in, they don't think it's as deep or they can't see the lines like Magistrate Hawkins was speaking of earlier. You lose them in the water, and before you know it, you're going to be off the road. And then it becomes a whole nother situation. So if you come across a roadway where you believe the water is covered, just turn around and find a different route, please. Thank you.
Thank you. Magistrate Jeffries.
Yes, sir. Just I was going to mention 393, but thought they did a pretty good job there. There was a little overspray on some of the lines, but I think they've done a good job of with the blacktop, and so anyway, hopefully I think some of that will fade or whatever here on the painting of the lines. But they have moved now. KYTC, or the crew that's doing the work, has moved here to 146 to north to 42. So I think I got some emails a while ago saying that they have milled out there at the Harrods Creek Bridge, and it's pretty rough. So if you're traversing through that area for the next few days, just be aware that you're going to have a pretty a lot of bump there when you go on the bridge at Harrods Creek. So just watch your speed and give those folks that are working on the highway plenty of room and slow down a little bit. So hopefully it won't take very long to get that part done from 146 here in LaGrange all the way out to 42. So that's all I have, Judge.
Magistrate Woosley.
The Parks this weekend is sponsoring a sprint triathlon starting at Wendell Park. They're going to be swimming at Wendell Park, and then they'll be biking, and we'll have the road partially shut down between 393 and Finley Road. Did they do Ironman? And the other road that runs behind the Reformatory. I'm just completely drew a blank here.
Dawkins School Road.
The other road.
And Bennett Lane.
Bennett Lane.
Bennett, yeah.
As they're biking, so they'll bike from Wendell, they'll go down 393, go across Finley to Bennett, come back, and then there's the running. So we'll have some road closures this weekend from about 7 a.m. till about noon or so in the Buckner area. And I also want to mention this afternoon, the Oldham County Police issued a golden alert. I'm sure we all got that notification, but it's Carol Reynolds. She's 81 years old, was driving a silver Ford Explorer with Kentucky license plate 614 V Victor M Mary L Lincoln. So if you see a silver Ford Explorer with that license plate, call 911, please. That's all I've got, Judge. Thank you.
Magistrate Tice.
Nothing. Thank you, Judge.
All right. Magistrate Likens.
Just one thing about the Oregon Creek farms out there. I think every road in Oldham County was probably gravel or dirt at some point in history, and somehow we managed to get those paved one by one. So I think where there's a will, there's a way, and if we can form a committee and see how we can help those people out, let's do that.
All right. You think Hillcrest was a gravel road at one time?
Pardon?
Hillcrest was a gravel road at one time? I'm just kidding.
You know what I mean.
We did have Ironman contest this weekend. We got through our half Ironman. I don't believe there were any injuries. I didn't hear about anything. I thank all of our police, sheriff's deputies, and EMS for participating. I only had one complaint from one individual, and so I understand there's a little bit inconvenience sometimes, but Ironman has been. We've received grants from the Ironman Foundation every year that they've run here. We had always in the past gotten $15,000. They call this a half Ironman, so we might be getting $7,500. I don't know, but it's been used for swimming and running and biking activities sponsored by our Parks Department. So we do appreciate that. One final note, we did receive word this afternoon that our county clerk's father, Junie Roberts, passed away. And sorry that, we only know that, so we express our deepest sympathy to Amy Alvey and her family on the loss of her father. So I'm sure there'll be more information about that visitation later. Is there a motion to adjourn?
Second.
All in favor, please say aye.
Aye.